So continuing chapter four, this anytime we get a listing that's for a 55 plus community or senior housing, we have to, before we put it in the MLS, we have to accompany it by a form like this. This one is from the Garden State MLS. They want to make sure that when we put a listing in there, that it is actually housing meant for older persons. And that's what the form is called, housing meant for older persons. So that stands for the 55 plus community as well as senior housing. Otherwise, we would be discriminating against the familial status requirement. We can't just say that something is age restricted if we can't prove that it's age restricted housing. Otherwise, that's just discrimination based on age for against children and such, and people with families. And the only exception to that is the senior housing and 55 plus community. So we have this form here, housing for older persons. It's just to certify that the housing is meant for that, signed by the owner of the property here. But they put down all the information about the complex, and we got to submit that to the MLS along with the listing paperwork.
Okay.
Now, here's some more discrimination. It could be discrimination, considered discrimination. People who have service animals.
I
Okay.
read about this.
Yeah, service animals, for people with disabilities, they need them, but there's all kinds of disabilities, and who's anybody to say what the disability is that you have, and if it's real or not, because you're getting around, walking around, you look normal, you look fine. Yeah, well, people got mental disabilities too, and you can't see what's going on in people's heads. So
Yep.
service animals and there's the Fair Housing Act. This is a different FHA than the Federal Fair Housing Administration. There's such things as FHA loans we're going to learn about in a different chapter. This is a different FHA. This is the Fair Housing Act, a law that basically says that it's unlawful for a housing provider to refuse to make reasonable accommodations that a person with a disability may need in order to have equal opportunity to fully enjoy the housing that they're living in. So assistive animals are not pets. They work and perform tasks. They provide therapeutic or emotional support for individuals with disabilities. And there's two types of service animals. We have service animals, which perform a service, okay? And then there's ESAs, the emotional support animals, that just having them there with you calms you. This is for people that may get panic attacks or seizures or suffer from PTSD and things like that. So the ESA, those emotional support animals, provide therapeutical emotional support for individuals with mental or emotional disorders like depression, anxiety, phobias. And the landlord may not inquire about the person's need, only the right to verify with a letter from their therapist or doctor on the licensed letterhead that the tenant does have a need for an emotional support animal. So a valid letter is written on a mental health professional's letterhead along with the contact information. That's all they could ask for. They don't. All they need to know is that you got a prescription and you have a need for one, and that's what that letter from the medical professional would do. So a landlord can deny animals that pose dangers to other tenants that are disruptive or cause undue financial burdens to the landlord. Additionally, neither service animals nor ESAs are permitted to roam off their leash on the property. They always got to be in their handler's control. Now, service animals can be just about any type of animal. I'm sorry, the emotional support service animals can be just about any type of animal. But those that are classified strictly as service animals can only be dogs, and in some circumstances, miniature horses. So I put together a couple slides here and a write-up on this stuff. So that Fair Housing Act is a federal law, prevents discrimination against those tenants with animals. It violates the tenants' rights, the service animals or emotional support animals, if the landlord were to deny them. So under the FHA, disability is defined as a physical or mental impairment which significantly limits a person's major life activities. So even if a lease says no pets or restricted pets, the landlords are required to make what we call a reasonable accommodation to allow pets to serve as assistance animals, which include those that provide emotional support. And assistance animals are in a different legal class than pets who are not assistance animals because and their pet fees and pet restrictions, even if the landlord has them, they don't allow them. They have to allow the service animals and these assistance animals. And any pet fees or whatever are waived as well. They cannot charge additional fees for having a service or emotional support animal. So they're animals that work, assist, and perform tasks and services for the benefit of the person with the disability that helps improve their condition. And there's no official certification or training, contrary to popular belief, for assistance animals. Just the fact that like emotional support, just the fact that they're present helps alleviate the symptoms. But those that assist and perform tasks, well, there's no official training for them either. Who's to say you can't train them yourselves, right? So that's why they did not Congress didn't create a official training program that they need to go through because that could be burdenful on those who may not be able to afford it. Because training these animals could cost upwards of $25,000 to $50,000 or more to get these animals trained. All right, and any type of breed, there's no breed or weight restrictions on assistance or service animals. So even a pit bull can be a service animal. Now, what's the difference between service and assistance animal? Well, service animals can only be dogs, and they're categorized as animals trained to do specific tasks for the owner. The most common example is a guide dog for blind people. Service animals are allowed in public accommodations anywhere or on planes because the owner needs the animal at all times. Now, an assistance animal can be a cat, dog, or other type of companion. Assistance animals do not need to be allowed on planes or in public spaces like they once used to. This became an extreme burden and nuisance by people who try to pass their pets off as assistance animals. They go to a website and they pay a fee, and then they get a document that says your animal is now assistance animal, and look, we're going to add them to our database. So if anybody's got a question, they could come and search the database and see it's legit. Well, I call bull cocky on that because you ever hear of HIPAA laws? Those are the medical privacy laws. There is no searchable database open to the public where you could see if somebody has a medical need. That's nonsense right there off the bat. But a lot of people would go to these websites and they seem legit. They got all this information. They even got like legit looking logos and stuff, and they're so professionally put together. But it's nonsense. Okay. So these assistance animals can be trained to perform tasks or can be for emotional support. And the emotional or physical benefits from the animal living in the home are what qualify it as an assistance animal. And all they need is that letter from that doctor or therapist. Now, the fact that the term service animal is often used by landlords and public housing authorities to refer to both service dogs and assistance animals often creates the confusion. So here's some examples of assistance animals. A cat or dog that detects and alerts their companion to oncoming seizures. A cat or just say an animal that relieves the person's depression or anxiety. An animal who reduces the person's stress-induced pain. Or a bird who alerts a hard of hearing companion when somebody comes to the door. They could put out those high-pitched sounds and fly around and that. Okay. These animals are amazing. I found this video somewhere on social media, so I copied it and put it here. So this is an example of how a service animal would be alerting their owner. I think in this case, her blood sugars are running low, and she could have a seizure if she doesn't take her medicine. But if you notice, a lot of times service animals, they're large dogs. They're not these little lap dogs because they need to either guide and be able to pull the person or lean up against them to let them know, hey, you're about to have a seizure. So if you see like a service animal starting to lean and push their weight into the person, that's how they alert their human that there's a problem. Watch how this dog alerts his human that there's a problem.
Is it coming out? Kabuli, let's see.
See, so it's amazing how they can tell, how they could sense, they could sniff it out, they could smell if the blood sugar's running low. There's a lot
That's
involved.
amazing.
Yeah, there's a lot I mean, just imagine the training involved like that. Most people can't train their dog not to poop on the floor. And this
Right.
is trained how to sniff your blood sugar level and then alert you to the fact that it's running low, knowing that there's a danger there. That's amazing. These animals are amazing. That's just beautiful right there.
It is.
You know,
Oh,
yeah, look at that face. Come on, who can't
I
love
know.
would you?
Sometimes I want a dog and sometimes I don't. I'm more of a cat person.
Is it coming out?
But then I see stuff like this and I'm like, oh, I want a dog now. A
You
lot
could
of
have
work though.
both. I mean, you could train dogs. Listen, if you got animals that are together, and they live together for a while, they could be cohabitate well. It just really depends on the dog. I wouldn't go out getting any pit bulls or Rottweilers or
Right.
anything like that to be with your kitty.
Well, my cat is old and cranky, so
Yeah.
maybe when she passes.
Well, you get some dogs that they could tolerate them even when cats swat at them.
Well, I don't want to stress my cat out.
Yeah.
That's why I
Yeah.
wouldn't get another animal.
Gotcha. Gotcha.
Yeah.
So, how do we demonstrate your pet's a service animal or an assistance animal? Once again, just a letter from your doctor or therapist, and make a request to the landlord that you want them to provide a reasonable accommodation. That's it. And then, if your landlord refuses to accommodate, well, they could be guilty of discrimination. So now you can file a complaint with your local housing authority or HUD. Go to your attorney general's office, and HUD will investigate, or the attorney general under New Jersey state laws, which we didn't get into yet. The attorney general is the investigator for New Jersey for the state enforcing the state anti-discriminatory laws. HUD investigates the violations of the federal housing laws. So all types of housing are included, including public housing under the FHA, except for rental dwellings of 4 units or less if the owner occupies one of the other units.
Hey,
So,
Victor, really
yeah.
quickly.
Uh-huh.
I'm sorry. So the Attorney General enforces the state, right?
Yep.
And HUD enforces.
Yep, the federal
Fed-
anti-discriminatory laws. Yeah. So Civil Rights Act of 1866 and the Civil Rights Act of 1968 enforced by HUD. New Jersey anti-discriminatory laws, which we didn't go over yet, are enforced by the state's law enforcement officer, which is the Attorney General.
Okay.
So the single family homes are sold or rented to the owner without the use of a broker, or housing owned by private clubs or religious organizations that restrict the occupancy of its housing units to its members. These are the ones that are accepted, have an exception for that Fair Housing Act. Now, service and service and assistance animals are technically not pets, so you cannot charge additional fees to have a service animal. Sure, you can security still. You could even charge. You could charge security still to the tenant, as long as it does not exceed the 1.5 times monthly security deposit. Remember, it doesn't matter what you label it as, pet security, just security, call it whatever you want. In case deadbeat don't pay me my rent and does damages security, the total security that you can collect, it cannot be any more than 1.5 times the monthly rental figure. I think we discussed this before with the when we looked over, can a landlord charge a tenant or can a tenant pay rent in advance for like the first month and the last month? Or can a landlord ask for that? No, because whatever they call it, it's still security. So the owner may still seek money from the tenant if their animal causes damages. Also, if they're a nuisance animal, they can have them removed through the court through legal proceedings. So here's a question. How do fair housing laws apply to real life situations? John's been diagnosed with a severe depression, and he's disabled as defined by the Fair Housing Act. His doctor provides John a dog to help alleviate some of his symptoms, and John asked the landlord if he could have a dog as a reasonable accommodation for his disability. His landlord says yes, but then he tells John that he'll need to pay a $250 pet deposit and must provide proof that the animal's trained. So the question is, did John's landlord correctly handle this request under the Fair Housing Act? And what if John wanted a cat or ferret instead?
He did not handle it correctly, no.
Why?
Because he's not supposed to charge a pet deposit or a pet fee.
So no, he did not handle it correctly. John, because he can't charge a pet deposit for his service animal because it's not a pet, but a service or companion animal required for his disability. So that's correct. Further, the landlord cannot ask for proof that the animal's trained.
Oh,
Lastly,
the wording.
Yeah.
The wording.
And lastly, the companion or assistance animal doesn't have to just be a dog. It could be other animals like cats, ferrets, or birds. Okay.
Service animal can only be a dog, right?
A service animal can only be a dog, but there's two. Like I said, there's don't focus in on that as much. If they on exams, they're not going to trip you up on this because the law is very complicated the way that they word it. You know, there's a classification of service animals and assistance animals. Okay, service animals can only be dogs. Now, as far as assistance animals go, there's two classifications of assistance animals. They could be service animals or emotional support.
Gotcha.
Okay, so it's kind of weird because you have the term service animal used twice, you know, to describe something a little bit different.
Yeah, I understand. It could be tricky.
Yeah. So yeah, just on exams, just if they talk about service animals, assistance animals, just consider them the same thing. Okay. All right, check this out. This is a little bit older, but this is what was happening when people were allowing service animals, assistance animals, and Congress wasn't so clear on this. It started really creating a problem.
The largest airline that cracked down on the so-called emotional support animals since that song. The policy change was prompted in part by a passenger who tried to board a United flight with a large peacock on Sunday. Delta announced similar restrictions just last month. CBS News travel editor Peter Greenberg is at United's hub at Newark Liberty International Airport, and that's where that peacock was grounded. Peter, good morning. Most people don't think of peacocks as emotional support animals.
No, but they are. In fact, more and more airlines are reporting that the number as well as the types of emotional support animals is reaching crisis proportions. Now, we're not just talking, as you can imagine, dogs and cats. In fact, the interior cabins of some flights are beginning to resemble Noah's Ark.
This woman is wrangling her peacock into the airport.
United Airlines says it warned the peacock's owner 3 times that Dexter would not be allowed to board.
Dexter.
The bird lives with an artist in Brooklyn who claimed Dexter was her emotional support animal.
Okay, listen to her explanation when she starts explaining about why this peacock is an emotional support animal. You tell me if she's just taking advantage of the system, or if she has a legit need for an assistance animal. She even tells you it's just because there was like an attachment that was formed. Okay, so that's after the fact. So it's not really that you had a medical problem and a need and then you got the animal. It's just that I guess you knew a doctor and you got a doctor to sign off on it because you had this weird connection now with the animal. Watch this. This is really weird.
In this 2016 interview, she described how she found it.
I got him originally for an art project, and but then this happened, and I was like, "Do I have a peacock cutlet in my neck?" Yeah. Yes, I do.
United Airlines already prohibits non-household birds, hedgehogs, ferrets, spiders, sugar gliders, and other exotic animals. Its new policy.
You know what? These sugar gliders. You ever hear these sugar gliders? You ever see them? I had a girl in one of my classes one time. When we were meeting in person still, and she was sitting right in the front row, right in front of me, and she kept going like this, and it looked like she was playing with her boobs all day in class, right in front of me. And so during break, I was like, "What are you doing?" I was like, "It's so distracting." I was like, "What are you doing?" Yeah, and she pulls out. She got a sugar glider that keeps climbing around in her chest, and she's trying to like adjust them. I'm like, "What?" And she's like, "Well, he gets really agitated when I'm not at home, and so." And I was like, "Okay." I had to know why she's playing with herself in class.
Right.
That's what it looked like. And then she pulled out this thing with giant eyeballs. They're really cute. But they're very affectionate animals. And these things can live upwards of 15 to 18 years.
Wow. So she just had that thing in there pooping and peeing all day?
I guess so. But she was like, yeah, when they poop or they pee, it's just like a little tiny dot, And I was like, yeah, it's still poop and pee, but whatever. But yeah, that's what they do. These things, if you ever watch them, watch a video of them maybe on YouTube where they're like up on a furniture piece. They actually, when they open up their legs, they got a webbing here and they kind of like glide, they fly, they could go for long distances too. But it's like they leap on you, they leap and they jump to you if you call them. It's really neat. But they're nocturnal animals. That's why their eyes are so wide. They like to be in the dark.
Mhm.
So,
It's cool. Now I want one, but my cat will eat it.
well, yeah, that could be a problem. The kitty, yeah. But they'll probably be able to get away. But then again, cats are pretty quick. I've seen a lot of those videos with the cats versus snakes, and cats have much faster reaction time than a snake does.
Yeah.
Those, poisonous snakes. Seen a lot of
Well,
reactions to those.
my cat's big and fat, so she's very lazy.
They're still probably faster with the swatting than you give them credit for.
Yeah.
New policy requires owners to give 48 hours advance notice when flying with a support animal, provide a letter from a mental health professional, and documents from a veterinarian showing the animal is vaccinated and not a threat to the public.
We've had roosters and ducks and pigs and monkeys.
Sarah Nelson is president of the Association of Flight Attendants and says she applauds the new policy changes.
But what we really need is for the Department of Transportation to act with guidelines for the entire industry.
United saw a 75% spike in comfort animals from 43,000 in 2016 to 76,000 last year. The critters sometimes relieve themselves in damaged planes. In June, an emotional support dog bit a Delta passenger. Can pigs fly? In 2015, we showed how easy it was to get one on a flight. A Colorado counseling center provided CBS this morning with a letter prescribing the pig as the primary treatment for a psychological disability. Tom Panic, CEO of Guiding Eyes to the Blind, says people are passing off their untrained pets as service animals.
As a person who is blind, my access rights are being infringed upon when somebody passes off a fake service dog.
Now, the new policies for United and Delta kick in on March 1st, and American Airlines is expected to follow suit. But we should note that the new policies only apply to emotional support animals, not the trained, specially dedicated animals that fly for and with people with disabilities. John?
Peter, thanks.
Yeah, people take their pets very seriously. We get it, but you see a lot of people taking advantage of that policy. So I think it's good that they're trying to figure out a way to crack down and make sure that the legit animals go.
And there's even more people that are ignorant to the fact they think that they could go to a website, sign up, and their animal, they could take it anywhere because now it's a legit service animal when it's not. So here is some updates on these laws, okay? Where can service animals and emotional support animals go? Well, service animals can only be dogs, and in some instances, miniature horses. And emotional support or assistance animals. Let's see those two classifications. Emotional support and assistance animals, they do not any longer need to be given access to public places, to bars and restaurants and such like that. Although you still see tons of people taking their animals out to these places. And they're not legit because they got their animals just like walking around off leash or sitting in their lap or barking, and that's not a service animal. Service animals are trained; they're not going to do that. On traveling on planes, okay, they both need to be let into housing. Service or these emotional support animals are not trained or registered or certified. Neither animal is. But service animals, they have to be allowed anywhere, including air travel and housing, and they are trained, but there's no official certification that they need or official training that they need to get. Training here means that they're trained for a specific disability, which goes well above and beyond the socialization aspect of obedience. You know, not barking and nipping at people.
I have a question.
Mm-hmm.
So the proof that you can provide that you have
A service, an emotional support.
So you can have an emotional support animal as long as you have a note from your therapist or doctor. What about a service animal? What proof can you provide that this animal is a service animal or
You could get the same thing, but it's not needed. You don't need to carry you don't need to get like a service animal is allowed in public places, air travel and all that. It could be obvious that there's a medical need for it. You don't need to carry around any kind of ID to prove that your animal is a service animal. This is another reason why people abuse it, because they know that people can't ask for proof. Otherwise, if it is a legit service animal, you're just harassing the person with the disability and you're infringing on their rights. So that's what makes it even tougher, because you got a lot of people that then infringe on those persons with disabilities rights, and you get a lot of people that have non-service animals out there doing these things because people are afraid to ask now because they're afraid of getting in trouble. But sometimes they do get confronted, and that's when now you see the people making selfie videos, and then they're like, oh, they're infringing on my rights. They're not allowing me. I got a disability. And it's like, yeah, every other person does. So they got a question, especially, if your animal's not on a leash. I seen one YouTube video like this that was put on Facebook or something, and this girl, everybody was like, oh, that's horrible how they were questioning you and they wanted you to leave the store unless you could provide proof, and you didn't have to carry proof. Oh, they need to wise up and learn the law and all this. And in the meantime, the girl did not have her service animal on a leash. She was roaming around. And then her excuse was, yeah, but I can't have them on a leash because according to my illness or my medical condition, I can't control my hands when if I'm holding the leash. That was her excuse. I don't know about that one flying. What kind of medical condition? You can't hold a leash. What's the dog going to do whether you're holding the leash or not? So.
Right.
But the public was so outraged over it. And of course, me having a little knowledge about this, I posted some resources and information for them. And they wanted to argue the point, but it was basically, I see it was this girl that she created this video and everything. And it was for some kind of show or program or one of these branded social media sites and pages. And they were trying to, they're a very big company, and they were trying to promote this, and I was like, well, you're promoting nonsense. I was like, this is clickbait. That's all it is, because in reality, she's supposed to have control of that animal at all times. That's what the law says. You got to be on a leash, she's like, well, I am in control of him. He's just not on a leash. Obviously not.
True. The law's the law,
Yeah. I mean, they're letting you have them in a public space, and now you want to keep pushing the limits. You get an inch, they want to take 10 miles,
Yeah.
All right. So fair housing, equal housing opportunity poster needs to be displayed. And that equal housing opportunity logo needs to be displayed on all of our marketing and advertising, or the words equal housing opportunity. Anytime somebody is offering housing or housing services, you have to show that you do not discriminate, that you offer equal housing opportunity for all. So HUD requires any business offering housing or housing services to display this poster, and failure to display it is evidence that you actively engage in discrimination. Intent to discriminate is not a requirement in order to be found guilty of discrimination. They only need to prove that a discriminatory act had occurred. And under HUD's guidelines, if you don't display the poster that you offer equal housing opportunity, that's the evidence that you engage in discriminatory acts of discrimination, which is a pretty low threshold to be found guilty of discrimination. So basically, if someone files a complaint against you, HUD will go out and investigate. They come to your office. If they don't see the equal housing opportunity poster, boom, they stop the investigation and you're guilty. They don't even ask any questions. So let's highlight this on page 70 and 71. Oh, wait. Okay, this is page 70. The poster's on page 71. And then this is on page 84 about being found guilty of discrimination. They say the complainant does not have to prove guilty knowledge or specific intent to discriminate, only the fact that discrimination occurred in order to be found guilty of discrimination. Okay, so this was on page 70, and then on page 84 is this.
Okay, got it.
All right. So back to page 70 there, and 71, this is the poster that you see. Got the house with the equal sign in it. That's the showing that the equal housing opportunity. Often you see this even on real estate agents' cards. They put it on their business cards too, and all their advertising to show that you offer equal housing for everybody, that you don't discriminate.
Okay.
Page 72, block busting and steering. Let's do these highlights. We're going to do the highlights, and then we're going to move on to the next slide to get the explanations on them. Instead of just reading this, I like to give a little better in-depth explanation in my own words on the next slide. Make sure you also underline panic peddling, because block busting is also known as panic peddling.
Okay.
Now, it's interesting, though, that they say that while these terms, block busting, panic peddling, steering, redlining, while they're not mentioned by name in the Federal Housing Act of 1968, both are prohibited by that law.
Okay. Pedaling.
You got all the links? Okay, cool. Yeah. All right, so Title 8 of the Civil Rights Act of 1968 is called the Federal Fair Housing Act of 1968. And the Fair Housing Act of 1968 makes these practices illegal, although they're not mentioned by name in the law. Block busting is sometimes called panic peddling. It's using discrimination as the tool to play on a homeowner's fears of a protected class, that these people are moving into the neighborhood, and then they put together a story to try to scare them away. So these people are moving into the neighborhood in order to scare them away into selling, to scare them into selling. So just blockbusting is discriminating against who? The seller, because it's using discrimination as a tool. You're going to try to use that to play on their fears by coming up with some kind of story about the people that are a protected class to try to scare them into panic peddling. You're selling your panic to try to scare them into selling. And then we have steering. Steering, well, let's just think about this for a second before we read anything. In the real estate business, who do we drive around in a car? Who are we steering around? We're not driving sellers around, are we? No, we're driving around buyers and renters, right? So steering is only against buyers and renters because you only steer buyers and renters around. You know, I think you'd like it better on this side of town better, or I think you'd like it in this town better. It's more suited for you. You know, when you start doing that, when you're the agent, when you're the person that decides where somebody should live, that's discriminatory act. Okay. You got to leave it up to them to be able to choose where it is that they want to be. So steering is basically limiting someone's options of where they can live by not showing them all the properties that are available that meet their criteria. That could be as just like sending them emails of available properties and you're filtering out the ones you're sending them. You could steer somebody in that way as well. It doesn't have to be physically behind a car wheel that you're driving them around. You're channeling those home seekers to or away from certain areas, or simply not making them aware that homes are available in these areas. And when the agent's the one who decides where the buyer or renter should live, that could be deemed as a discriminatory act. And redlining, once again, is not giving somebody an insurance, homeowner's insurance or a mortgage loan, even though they could afford it, as a means of discrimination. That's redlining. So that's not actually the term redlining. You know, I usually tell people, you know, just remember it deals with the finances, the money. You know, you use red ink when the finances aren't good, right? So you turn them down. That's a good way to try to remember that redlining deals with the money, but that's not really where the term redlining comes from. It comes from these redlined area maps. So there was actually maps where they drew red lines through them to certain sections of towns and such. And because of the population of the people or who was living there, you don't want to give loans to these areas because they're riskier areas. So here, let me show this video, and this video will explain it a little bit better.
In the 1930s, in the wake of the Great Depression, FDR is president. He wants to bring economic relief to millions of Americans through a collection of federal programs and projects called the New Deal. One part of that New Deal was the National Housing Act of 1934, which introduced ideas like the 30-year mortgage and low fixed interest rates.
Look at those mortgage payments. Look at the price of that house, $4,800.
I wish.
You could get into this house for only $960 down, and $27.62 a month of mortgage payment. Bang!
So now you have all these lower income people who can afford homes, but how do you make sure they don't default on their new mortgages? Enter the Homeowners Loan Corporation. The HOLC created residential security maps, and these maps, they're where the term redlining comes from. Green meant best area, best people, aka businessmen. Blue meant good people like white collar families. Yellow meant a declining area with working class families. And red meant detrimental influence.
Now, these red line maps, these security maps that they're talking about, you could still see these archived. You could do a Google search and find them archived in a lot of places, and you could search different areas throughout the country where they do have these samples of these maps available, showing you all areas all over the country that had these maps classified like this. And lenders would use these maps. Insurance companies would use these maps to determine whether they were going to give you homeowners insurance or give you a loan to buy a house in these areas. But it wasn't based on any financial criteria. It was based on your race. It could be based on where you were born, your country of origin. like back then, I would be discriminated against. Now, I'm not a person of color, but uh, I am Polish. And Polish people were foreign-born citizens, and they weren't, believe it or not, they weren't considered white. So they're discriminated against.
Is hazardous, like foreign-born people, low-class whites, and most significantly, Negroes. Again and again on these HOLC maps, one of the most consistent criteria for red line neighborhoods is the presence of Black and brown people.
Yeah. See, they look at, are you a foreign-born person and your color, and what the percentage of people in that area fall into these categories. These were some of the things that they used as a condition to give you a loan or homeowners insurance or not. This is illegal to have on any kind of loan application today. Lenders cannot consider these things. In the past, they did.
Let's be clear. Studies show that people who lived in redlined areas were not necessarily more likely to default on their mortgages, but redlining made it difficult, if not impossible, to buy or refinance.
All right, so we'll leave it off there. I know I got a couple more minutes here of this video, but I got this from an NPR documentary that was created by NPR, and they're kind of politically biased on some stuff too. So they try painting a slanted thing, a very slanted thing when trying to push an agenda on this now too. Now, there's a lot of facts. They did a really good job explaining and laying out the facts of how people of color were discriminated against in the past with this stuff. But then they start really getting into an agenda about how it excuses behaviors of today, and because of things that happened in the past to not even you, but your grandparents, they start getting into that kind of stuff in this video. And that's nonsense. I believe everybody should be accountable for their own actions of what they do today. And if nobody's holding you back today, then there's no limitations on you today. All right, moving forward.
1930.
So we have this other stuff that's going on today, which is really promoting this kind of behavior too. It's called disparate impact or disparate treatment. And at the beginning, they start explaining what disparate impact treatment is, and they use a lot of logic and sense to describe that. And then after they get you nodding your head this way, then they start going off track into some really off the wall nonsense, and then people just keep going with the flow because their heads are already nodding this way. This disparate impact treatment stuff is the same kind of things that during the Obama administration, he had assigned somebody to HUD. And this guy that he assigned to work within HUD, the Department of Housing and Urban Development, out of nowhere on his own, decided to create not even do a study. He just, he took studies or statistics that were out there, and then he used that to create a conclusion in a report that would be used by politicians afterwards to say our systems are all systematically racist because there's not an equal number of people in prisons that were convicted of crimes based on their race. If we separate them, the number of people in prison based solely on their race, if there's not an equal number of people that are white versus black in prison, well, then the system must be racist. It doesn't take into consideration, well, maybe more of these people are committing crimes than these people, it's not, it totally discounts that fact. It just says, well, if you got more people of this race in prison versus this race in prison, then the system must be racist. And therefore, you cannot draw any conclusions, and you can't, this is how they got to the point where we can't even do background checks on people now that you want to move in, you want to do a criminal background check on somebody. You can't, it's racist to do that, to do a criminal background check. It's like, wait, what? How is it racist to find out somebody committed a crime and whether you want them to live in your house or not?
So
No.
is that illegal to do a background check if you want to?
In New Jersey,
Are you serious?
this is recent. Yes.
Wow.
I'm telling you, all this stuff has happened in recent years. It started with Obama. Obama planted the seed by putting these people in these departments who created reports like this. It's kind of like, you know how on social media you may make a post that gets censored, and Facebook takes it down, or Instagram or one of these other sites. You make a post and they say, well, it could be misleading or it's not true based on, and then they'll point to a news story. And then you look at the news story and you say, wait a minute, that news story is bullshit. But you can't question it because it's out there, So basically what a lot of the censorship, how it works like on Facebook is if they don't like what you're writing about, or if they don't like a post that you put out there, you get these people that if they don't have a news story that supports their argument, they'll write one. And then they'll point to that as the evidence to censor your post and take it down. And then it's like you got to jump through all kinds of hoops to try to even argue the point. And a lot of times those links never work too. So this is the same kind of a scenario. So basically, Obama appointed this one guy who created this. It's not even a study. It's an article based on statistics. And then he came to his own unilateral conclusion, which is totally flawed, not scientific or making sense in any way, shape, or form. And then you got politicians that are using that as the basis of the evidence for them passing laws or putting policies in schools or creating laws on doing background checks and things like that. This is how our society is being shaped right now. It's based on one simple characterization by one guy that is very misleading. And they point to that as the evidence. And then when they create a law based on that story, now other laws can be created based on this other law and practices that other towns are doing or the government. But that law was created based on this flawed story, and it just keeps building and building and building. This is why we're seeing mayhem right now in our country. It's kind of crazy. So let's look over it. Don't take my word for anything. You guys can do all your research on your own on this stuff to find out. I don't tell anybody. Look, anybody can have an agenda. I don't, but I like to look at things from a neutral stance and perspective and just give my 2 cents on it. I tell people all the time that listen to me that have to sit here in class, don't take my word for it. Do your own research on this and you can find it out on your own. As a matter of fact, pay close attention to the words in the videos and the articles that we read here in this class and come to your own conclusion. And it kind of supports the evidence of my claims that I'm saying. So let's just look at this for a second. Disparate impact is sometimes referenced as a disparate treatment or adverse impact. Is a policy or practice that seems to be neutral, but in fact may disproportionately impact certain groups of people. This results in discriminatory practices, resulting in unequal treatment and hindering equal access. For example, a lender or property management company may require full-time employment. On the surface, this requirement seems fair enough. However, it discriminates against someone receiving public assistance or disability payments. Now, the Department of Housing and Urban Development, which enforces the Fair Housing Act of 1968, published guidelines explaining the use of criminal history to exclude people from housing may violate the prohibitions in certain circumstances. Housing providers may not use criminal history as a pretext for intentionally discriminating based on race or national origin. Okay, now it's interesting the way that this article or this paragraph was written here, because it sounds like this is based on something that was part of the Fair Housing Act from way back in 1968. This has been going on a long time. But it actually just says The Department of Housing and Urban Development, HUD, enforces the Fair Housing Act of 1968. Okay, yeah, okay, we know that. So what? What does that have to do with what's going on now? Well, they published the guidelines explaining the use of criminal history. Yeah, but when did they do that? They did that during the Obama administration. And it excludes, it excluded people from housing may violate the prohibitions of certain circumstances. Housing providers may not use criminal history as a pretext for intentionally discriminating based on race or national origin. How do you intentionally do it? Well, the first thing that they say here makes sense. If you apply a criminal record-based restriction against protected classes differently, yeah, that's a given. That's discriminatory straight up. In other words, if you do background checks on Black people but not on white people, yeah, that's obviously discriminatory. You can't do that. But what's wrong with doing background checks on everybody that comes in? Is there something wrong with that? What do you
I
think?
don't think.
You don't think so, right? Because it's done evenly across everybody. Well, you're racist. You know that? Because, it's not about doing the background check equally. It's because the criminal justice system is systemically racist because there's not an equal number of Black people and white people in prison to begin with. So therefore, because Black people are incarcerated at higher rates than white people, it's systematically racist. And if you're using that information that they were arrested, well, that's racist. It's like nonsense, For example, a management company with the intent of keeping all of its tenants safe might reject an applicant based on a criminal history. Okay, as they should, because they could be held liable if other tenants there are subject to dangers because you have a criminal living there. You're supposed to keep the other tenants safe. Now, this ignores groups who are incarcerated at higher rates. Now let's get down to it. Than the general population and may not result in a safer environment. Hold on. First of all, because groups, why are we grouping people? Let's look at people at an individual basis. Were you arrested? Did you actually commit the crime? How about that? Let's analyze it on that way. Why are we lumping them all in groups? And what kind of groups are we talking about here? They're talking about based on race. They're saying, because there's more of these people in prison than these people in prison based on their color, their skin color. Now that's racist thing to do. So yet another example is a zero tolerance of violence. Now this one's really wacky. They're really pulling at strings this way on this one, trying to justify the previous statement about the groups of people based on their race that were incarcerated. It says, let's just take a look at domestic violence. And women experience, perhaps 25% of women have experienced a domestic assault. So a 100%, a zero tolerance policy for domestic violence would negatively impact women. Huh? They're the victim. They're saying zero tolerance on violence. So basically that means that the picture that they're trying to paint there is that if you were involved in domestic violence as a victim, well, you were still involved in the fight. So therefore you're not allowed. That's just nonsense. Who does that? Nobody does that. That's ridiculous.
Yeah.
But that's how they wrote it up here. So like it's like the arguments they make are total nonsense too. And if anybody were ever to stop to actually question them, it would be called out as BS right there on the surface. But the thing is, nobody's asking these questions, so it's allowed to, carry on and build up. So New Jersey now has something called the Fair Chance in Housing Act, the FCHA. This began January 1st, went into effect January 1st, 2022. This is that law I'm talking about. So New Jersey and a couple of other states like Illinois, New York, I think California, New Jersey has a Fair Chance in Housing Act that prohibits landlords from generally asking about criminal history on housing applications anymore. In most states, landlords are prohibited from running a criminal It's not in most states. That's nonsense. But it says here in most in most cases, I'm sorry. In most cases, landlords are prohibited from running criminal background checks on an applicant until a conditional offer of housing has been made. So that's basically the rule now. When you're renting out a property, if a tenant expresses an interest, you have to agree to rent to them first before you could do a background check.
Makes no sense.
So now, after you agree to rent to them, then you have to tell them this agreement that allows you to rent from me is now conditional on a background check. But I've accepted you as a tenant, conditional on this background check. Now, if you already accepted somebody, in order to back out of that, you need a legitimate reason to. That's their objective of how they're trying to back you in a pigeonhole and open you as a landlord open to lawsuits. So basically, you can't choose who it is that you want. You got to choose whoever it is without knowing their details. That's like not checking somebody's finances before agreeing to rent to them, except you're doing it based on their criminal history. So you have to agree to allow them to rent from you before you check their criminal background. And then if you wanted to deny them rental because of their criminal background, well, you know, the criminal justice system is racist. So therefore you're racist and you're using a racist reason to back out. And therefore you can be sued. Okay. And you discriminated against them. So
What about for like sex offenders? What if I went on that the website?
We're gonna get into the details a little bit on this now too. Okay, we're backing into it slowly. Okay, we're gonna get into that. So here's a little write up that I made. These are my words here. It says the best we could do with contradictory guidance like this is to be a good person, treat everybody equally, fair and just, and hopefully you won't get sued. Now, politicians, in the name of fair housing and something that they've been throwing around, this new term equity, they've been throwing around a lot, are justifying a systematic racism claim by absolving individuals from their personal responsibility and accountability for their actions. Instead, they judge individuals based on racial groups that they fall into as the reason for excusing them. Law-abiding citizens wanting to safeguard their family, property, and tenants, they have a legal responsibility to do so, but they can be found guilty of discrimination if they deny renters who have a criminal history. It sounds crazy, but this is now the law in New Jersey. Okay. This is my interpretation of it. Okay. So keep that in mind. These are my words and my interpretation. Oh my gosh.
I agree. You know, just crazy.
It is, and we're gonna get into it a little bit deeper. I don't know how my phone rang. It's a weird number. It says user before a phone number, and then it rings. I don't know what's up with that.
You know, I'm a single mom of 2 kids, and I want to rent, you know, a room out, and I can't now because I can't do a background check. There's no way I'm gonna.
We're gonna get into the details of that in just a moment. Okay. But let's first look at this lawyer from NAR, how she explains the disparate impact treatment and how it works. And if you listen to her arguments, like halfway through them, if you really, really pay attention to her words, because she's just explaining the law, okay? And she does a good job trying to explain it with a straight face, but some of her words start to contradict themselves. If you pay close attention, what she says is contradictory. I'll even stop the video and point out where. You can hear this, right?
Yes.
Is the window to the law. I am Mame Nyamiche, staff attorney at the National Association of Realtors. In this episode, I will discuss why it is important to give your criminal background screening practices a second look in order to avoid a fair housing violation. In fact, several housing providers have found themselves faced with lawsuits alleging the misuse of criminal history in violation of fair housing laws. In New York, a housing provider recently settled a case for over $1 million where the plaintiff alleged that the housing provider maintained an overly broad ban on renting to people with criminal records.
Now, it doesn't say they were found guilty of anything or that they did anything wrong. It's just that they settled a lawsuit and their insurance, I guess, decided to pay $1 million just to settle the issue. Now, if you notice the wording, they got sued, they settled. Okay, that doesn't prove guilt. That doesn't admit guilt. That doesn't say that they did anything wrong. It just means that they paid out somebody who sued them so that they go away.
In Florida, as many as 48 Florida housing providers were also sued for the alleged improper criminal background screening of prospective tenants. The use of criminal histories to make housing decisions has long been on the Fair Housing Advocates' radar. In 2016, HUD issued guidance urging housing providers to exercise caution when implementing criminal history policies and practices to make housing decisions. In the guidance, HUD reported that African Americans and Hispanics are arrested, convicted, and incarcerated at disproportionate rates compared to the general population.
Okay, so let's use the same argument. Let's go with their argument and say, okay, what you're saying here is 100% legit. That's discrimination because African Americans and Hispanics are arrested and incarcerated for crimes at a much higher rate than white people are. Okay. Well, first of all, let's evaluate why is that. I mean, if they're a smaller segment of the population, but there's more of them in prison, that means that more of them are committing crimes. Why is that? Let's get to the root of the problem. This wasn't the problem back in the 60s and before the 60s. Before then, we have a destruction of what we call the nuclear family, where you have mothers and fathers in the family where they all stick together. You know, a lot of this is falling apart in the Black communities, especially where you get the fathers, they disappear, you know, and you don't have that family structure. I mean, when you have the family as a whole, the mother and the father around, the kids tend to grow up a little bit more stable and more respectful. Now, that's not in all the cases, of course, but you know, how is the family raising their kids? You know, that's the thing. Back in the day, you'd always have that, but it's way more often in these communities where you don't have the full family around. Now, that's one argument about why. But let's just take a look at if we have African Americans and Hispanics that are incarcerated in higher levels, and therefore it's discriminatory because there's not an equal number of white people in prison as there is in African Americans and Hispanics. Let's use the same argument about this. Well, what about Asians? There's way more white people that are incarcerated than there are Asians. Does that mean that white people are being discriminated against because there's way more white people in prison than there are Asians? I mean, you could make this argument if you want to super hyper focus in on certain races, comparing one to another. That just shows on the face how these arguments are just to promote an agenda of somebody. You know, this is not really based in or rooted in any facts. If we were to do that, we would just look at the individuals and say, hey, listen, did you actually commit the crime? Are you in prison for a legit reason? Well, then you're a freaking criminal. Okay.
Exactly.
Doesn't matter your race. You know, how about that? Let's not separate criminals based on race or classes. You know, there's rich criminals and there's poor criminals. So are we going to start separating them based on their money, how much money they had? You know,
General population, resulting in criminal history-based barriers to housing and creating a disproportionate impact on minorities. While persons with criminal records are not a protected class under the Fair Housing Act.
What did she say? People with criminal records are not a protected class. All right, I agree with her. What about you?
Right.
Okay.
Race, color, and national origin are, and the improper use of criminal history to make housing decisions may have a disparate impact on those protected classes.
How?
Under a disparate impact analysis, a housing provider may be held liable for discriminating against a protected class absent any evidence of intent or motivation to discriminate.
Say what? Let me rewind that. Let's listen to that one more time. You know, when people start batting their eyes and they're talking and they're looking away, you know, I really pay attention to what they're saying.
Class, absent any evidence of decisions, may have a disparate impact on those protected classes. Under a disparate impact analysis, a housing provider may be held liable for discriminating against a protected class, absent any evidence of intent or motivation to discriminate.
That's scary. You could be found guilty of discrimination absent of any evidence or intent to discriminate.
Meaning, liability may arise when a facially neutral policy or practice has or predictably would result in a disproportionately negative impact on a.
Okay, so how could you have a disproportionately negative impact on somebody if you have a neutral policy that treats everybody the same? You see where I'm going with this?
Protected class under the Fair Housing Act. Some states and localities, such as Illinois, New Jersey, and the District of Columbia, have even enacted laws restricting a housing provider's use of criminal records. Consider these best practices when using.
In other words, we can't do the background checks except in certain circumstances can we use that against them. We're going to get into that after this video.
Criminal history to make housing decisions. Have a written criminal history policy. Apply criminal record policies consistently.
Check.
Do not ask or consider arrest without conviction.
Check.
Avoid blanket bans on applicants with a criminal conviction.
Why? What if I just don't want a criminal living in my house?
Be sure to exclude only those with convictions that present a demonstrable risk to resident safety or property.
And how would you determine that? I mean,
You can't do the background check.
well, hold on a second. Even if you could do a background check, individuals who have convictions that present a demonstrable risk. How do you demonstrate a risk? Well, the fact that you've done the crimes before. That's a risk in itself. You're willing to do the crime. Yeah, but you served the time, so you have to demonstrate that they'll do it again. How would you do that? I don't know. How would you?
We have to take the risk.
Yeah.
Document housing decisions.
Why would you document your housing decisions on who you're going to rent to and how you're going to make that decision? Sounds to me like they're requiring you to put together the evidence for a case for somebody to sue you, that you need to maintain those own documents that they could use against you.
And become familiar with local and state laws that apply to a housing provider's use of criminal history. For more information on use.
That was a whole lot of nothing burger right there. That was a lot of contradictory advice right there. That did not teach me anything. That just showed me that these laws are wacky. If you stop it and analyze those words at each step of the way there, I don't see any benefit to these laws. All right.
None.
Before we get into the details of New Jersey's new laws and how we could do the background checks, the federal laws against discrimination and what we've learned so far, let's look at this case. This is a video that shows you, it was an undercover video from years ago. It shows you how, what happens if somebody discriminates. They file a complaint with HUD. HUD will investigate what the resolution is and what happens. This is actually from beginning to end in this news case here. So basically this newscaster, this broadcaster here who did this story, he was getting married. Him and his fiance, I think he was marrying a black woman. He's a white newscaster. They were looking for a place. And he feels like that they were discriminated against based on the way that this lady was talking. So what he decided to do is do a little sting operation and start sending white single people, white couples, mixed couples, black people in there just to see what her reaction was and how this real estate agent would talk to them on undercover camera, you know. And they caught her in this actual discriminatory activities. And then it shows you towards the end of it, you know, he even sent in his college buddy, his college roommate, who was a black guy, to go in there. And towards the end of it, you'll see that that guy, he even got a judgment out of it, and he didn't really even have an intent to move there. He just because he was part of this thing, and she did what she did discriminate against him. So he even got some money out of it. Check this out.
I'm listening. I just have to walk.
No African Americans living
Okay.
there. Is there a reason? Good evening. Thanks for being with us. I'm JR.
And I'm Darcy Strickland. The reason could lie with one real estate agent. A News 19 investigation uncovered what appears to be active discrimination inside a prominent Columbia high-rise.
News 19's Johnny Chappell has been working on this story for months now, and he joins us with the details.
A lot of us here put a lot of work into the story, and we hope that we can bring some possible good out of it, JR and Darcy. Who has the right to tell you where you can live? In January, I started looking to buy a new home. The very first place I visited, a realtor told me that for 25 years, the building had remained exclusively white. Her comment sparked our investigation, and our investigation has the federal government looking to take action. Looking up from anywhere between 5 Points and downtown, it's hard to miss 1829 Senate Street, a 30-year-old high-rise, 19 stories of high-end housing. In all, 96 luxury condos. The Heritage, all white on the outside, and there's a woman who may be trying to keep it all white on the inside.
We do not have a big neighborhood.
Anne Bryant is a longtime Heritage resident. She's also a realtor, and she shows just about every property that comes up for sale in the building. After my experience, we sent a team to investigate.
You get seven, that's good. I'm going to take you to see my son's unit. Okay.
A News 19 employee and her sister told Bryant they wanted to see what was available. Bryant showed them 2 occupied condos before going inside a condo for sale on the 12th floor. At the time, the residence was not on the market. Bryant said she thought it would list for around $170,000.
When I have a listing anymore, I mean, I need to put it in the computer because it's just, they go like that.
And she said that all prospective clients and their...
Well, let's stop right there for a second. When you get a listing, how soon do you have to put it in the MLS?
Within 3 days?
48 hours.
Oh, I have to write.
2 days. Within 48 hours, 2 days.
realtors go through her.
I need people to show in the building. I mean, if it's another agent showing, I need them.
Bryant went on to indicate that race determines whether she allows a person to see or inquire about purchasing property.
And I'm very careful when I make this statement. We do not have a big neighborhood here. And I think that is because we try to be careful and we try to not that nobody dislikes them. I work with them all the time. It's just that they tend to talking too much. They make the neighborhood do that because they don't take care of the moms.
Oh my goodness.
He makes those differences appear black and white.
We do have some OBLs and ones that have to do it for years. And I can take the date.
Those statements marked the third time we had heard Bryant referring to possible discrimination. She said it to me during my visit and to another News 19 employee during a previous trip. We showed the tape to Dudley Gregory, who's with the U.S. Department of Housing and Urban Development.
That conversation is enough to give me pause and that I would want to look further.
Gregory said,
Isn't he composed? Right? I'd be like, damn, we got to investigate. We definitely got something on this lady. He's just like, that conversation would give me pause. You know, he's real laid back there.
that Bryant's behavior very likely violates the federal law. Under the Fair Housing Act, a realtor cannot discriminate in 7 protected areas, including race.
The issue is how many people have been to that place that are minorities that have been denied even come through the door.
Local realtor Shelby King says those licensed in her field must complete class time every 2 years to keep up to date on the Fair Housing Act.
We are reminded about fair housing constantly.
King cites standard clauses in buyers and sellers agreements that deal with the law. She says there are certain things a realtor cannot discuss when showing a property, and that sometimes she's had to steer clear of a client's questions.
And they will usually preface the statement with, I'm not prejudiced, but what's the mix of the neighborhood? And I cannot address that.
So why would Ann Bryant, who's required by her profession to adhere to a federal law, risk losing her license? She agreed to meet us at the Heritage for an interview. You said you show most of the properties here. To the best of your knowledge, have you ever discriminated based on a person's race as to whether or not they can live?
Anybody can live at the Heritage. We have no discrimination of any kind in the building.
She denied ever talking about race with potential buyers, even after I told her about our investigation. We've had several people come to us and say that you say that this is not a mixed community, that it's only white people are allowed to live here.
No, I've never made that statement to anyone. I would certainly lose my license if I did a thing like that. We do not have a mixed neighborhood, but I've never made a statement like that.
So here's what's happened as a result of our investigation. Today, Ann Bryant submitted this letter to her employer. She's retiring from real estate effective immediately. To remind her agents and their agents of the importance of this issue, her former employer is requiring each agent to sign a second ethics policy. Also, I've spoken with the president of the Heritage Homeowners Association. His comments: we don't discriminate in any way at all on the issue of why Bryant has been on hand almost every time a prospective buyer looks at a condo for sale in the building. The president said, quote, she is not authorized by the board to show property. After viewing our tape, HUD opened its own investigation. HUD officials have told us their attorneys will be able to make a decision based on the possible violation of federal law very soon. And of course, J.R. Nashi will keep you posted.
Well, Johnny, has
Now watch
this
this.
realtor had any past incident?
We found out today, yes, she has. In 1997, a couple filed a claim against Bryant's former employer, naming her and her realtor as accusing her of steering. That's a practice referred to right here in the Fair Housing Act. Protected class, what type of housing or location would or not be appropriate for them, steering them in that direction. Her employer settled that claim, and Bryant had to pay a fine for that offense. So certainly a lot coming out of this story still to come, and we're going to continue to follow it in the next couple of days.
All right.
Now this guy's going to start reading off all the protected classes and stuff like that because they reached out to the local realtors association. It's funny, if you listen to him, he can't pronounce familial status. So he kind of skips it altogether, the word.
Thank you.
Well, we also contacted the State Realtors Association after our investigation of the Heritage, and this is how they responded to what we uncovered. Realtors adhere to a high standard of integrity and a code of ethics that requires equal access to fair and affordable housing for all, regardless of race, color, religion, sex, handicap, or national origin. They go on to say, as realtors, we deplore and will actively pursue action against any member whose actions run contrary to the federal or state fair housing laws or the Realtor Code of Ethics.
Well, we would like to get your feedback on our investigation of the Heritage.
Now, this isn't
there are
done
two
yet.
ways you can voice your opinion. You can call us.
We'll see the resolution to this in just 1
or you
second.
can log on to our website at WLTX.com and click on the Viewer's Voice section. We'll share more on this investigation, including some of the comments we received tonight with you tomorrow during our 6 o'clock newscast.
So here is the results. In 2005, HUD launched an investigation and reached a settlement with her broker, Century 21 Bob Capes Realtors. Bryant had to give up her real estate license, and then she died.
Oh my goodness.
So she
How?
died.
Naturally?
I'd say probably natural causes. She looked kind of old there.
Yeah.
But that's not the end of it, though. The investigation don't stop just because you died. So here we go. Jared Glover, this was that newscaster's roommate, his college roommate that he sent in during that sting operation as well, who was a black guy. He says, Jared Glover, a black public relations specialist for the city of Columbia, South Carolina, was Chappell's roommate, that's the newscaster, at the time Bryant made her comments. Come on. He filed a housing discrimination complaint in federal court last year that ended up in a settlement with her broker awarding him $90,000. He wasn't even
Wow.
looking for a house. He was just pretending to look for a house when she discriminated against him, and he got 90 G's out of it.
Do they know that? Do they know that he was
Yeah,
just?
well, it doesn't matter because she actually did discriminate.
Yeah.
You know,
Wow.
so her broker agreed to settle and give. So look, this shows you also that being a broker is a big responsibility. The broker can be liable for the things that their agents do. This is why their brokers will be reaching out to their agents, asking them, what are you up to if they haven't seen you in a while? You need to check in with me every now and then. I need to know. Otherwise, the broker will be better off just letting your license go if they don't know what you're up to, you know, because you could be doing something wrong that's getting them in trouble. And let's see, was that it? Okay, and then as part of the settlement, Century 21 agreed to provide fair housing training to its employees and an outreach program. Okay, but anyway, I like this example because it shows you from beginning, it shows you the actual discrimination that's occurring, it shows you an investigation afterwards and what the outcome was under federal law and how the broker could even be held liable. All right, so now let's get into the New Jersey law. Just a little recap first of the federal laws. The federal laws, we have the Civil Rights Act of 1866 and the Federal Fair Housing Act of 1968. HUD enforces those federal anti-discriminatory laws. And you have 1 year to file a complaint to have it heard before an administrative judge within HUD, or 2 years if you want to have it heard in federal court, at which time there's also no dollar amount limits on the awards or settlements. Now, this term right here, an injunction, on page 73, I want you to highlight this. Under enforcement in the second paragraph, actually, we'll have it on the next page. Here we go. Highlight this stuff on page 73. So for some reason on exams all the time, they give you this word injunction. Injunction is when a judge orders you to do something or not to do something. Okay. It has to deal with taking action or ordering you not to take actions. So that's what an injunction is. It's when a judge orders you to do something or to not do something. So, the LAD is the New Jersey law against discrimination. Now we're going to start getting into New Jersey law. New Jersey law against discrimination covers all real estate, not all property, just all real property, residential and commercial. Remember, the Civil Rights Act of 1866 covers all kinds of property, real property and personal property. The Fair Housing Act of 1968 only covers residential real estate. And New Jersey law against discrimination covers all real estate. Complaints are made to and enforced by the state attorney general's office. You have 6 months, 180 days to file a complaint under the LAD, the New Jersey law against discrimination. And those who interfere within the investigation are subject to a fine of up to $500 and 1 year in prison. The Attorney General's memorandum, well, let's examine that. The Attorney General is the highest law enforcement officer in the state. Memorandum is a fancy word for notice. So the Attorney General's memorandum is a notice coming from the highest law enforcement officer in the state. We're required to give this to property owners at the time we get a listing. You'll need to know that for exam. So the Attorney General's memorandum must be given to property owners at the time of listing. And licensees must refuse listings. Another exam question. We must refuse listings if a property owner indicates that they have an intent to discriminate. Now, here's a link to our shared Google Drive with the latest updated Attorney General's memorandum with this new law that was put into effect in 2022, January 2022, about the FCHA, that Fair Chance in Housing Act, that says you can't run criminal background checks on people unless they're conditional. And then in certain circumstances, can you only still not rent to them, which we're about to go over those reasons in a minute. But as we go over this actual document, we're going to read through the Attorney General's memorandum. Now, if you violate the LAD, the New Jersey Law Against Discrimination, we need to know what the penalties are for exams. Up to $10,000 for a first offense, up to 25 for a second, and up to 50,000 for further violations. Now, as far as violations for the federal anti-discriminatory laws, you don't need to study and remember them because they're off the wall figures. I don't know how you would. If we actually look at the book here, look at this page on 73. For violations of the federal law, for a first offense, it's up to $21,663. For a second offense, $54,157. They don't expect you to remember a weird number like that.
Yeah.
You know, and for further violations up to $108,315, you know. But for the New Jersey law, you need to know 10, 25, 50, 10, 25, 50. Okay. All right. So moving on. In case you didn't know, you can't use threats or acts of violence against somebody to get them to move or to force them to take on a buyer or renter. The LAD has a lot more protected classes in New Jersey than the federal laws. You know, the federal law, well, first of all, 1866 has two protected classes, race and color. They added two more in the 80s, which was religion and country of origin or nationality. There we go. And then the Fair Housing Act of 1968 has 7 protected classes. What's it? Race, color, familial status, sex. Oh my God, what are all of them right now? My mind is going blank. Race, color, religion, race, color, religion,
disability,
religion, nationality, sex, and familial status. And oh my God, why am I running blank now? Well, that's all right. We'll get to it again. Here, actually, here, let me read it off. I'll just back up in the book really quick and give it to you. Having a brain fart this morning. Sorry.
It's been a long week.
So the protected classes are race, color, religion, national origin, sex, disability. There we go. Disability and familial status. There we go. Disability was the one I forgot. Okay, so there's a lot more protected classes here in New Jersey. We have race, color, national origin, ancestry, nationality, creed. Creed means your doctrine of religious beliefs, whatever they are. Sex, gender identity or expression, affectional or sexual orientation, marital status, civil union status, domestic partner status, familial status, pregnancy or breastfeeding, actual or perceived mental or physical disability. That includes people who have AIDS, HIV, or things like COVID-19. Source of lawful income used for mortgage rental payments, like Section 8 housing choice vouchers or state rental assistance programs, or temporary rental assistance, which comes from Catholic Charities here in New Jersey, the TRA we call it. And we also have liability for services in the armed forces. I mean, how sick is it that we need to, it just shows you what direction our society is going in. When you need to make people who volunteer to serve in our military a protected class because they're discriminated against the young woke crowds, you know, it's like back after Vietnam, you know, where our soldiers come home and people spit on the soldiers. You know, you got these young crowds these days. We had to make the fact that you're in the armed forces of the United States a protected class to protect these people, our soldiers, our own soldiers. So it's also illegal to place any advertisement or make any statements or utterances that express directly or indirectly any limitation to offer housing on real estate based on any of those characteristics. Now, technically, under the FCHA, ex-convicts are now referred to as system-involved people, kind of soften that a little bit. You know, if you were convicted of a serious crime, you're a convict. You're in prison, you're a convict. And when you get out of prison, you're now an ex-con or an ex-convict. So these people that are rewriting these laws decide that they want to soften the effect of that because they like to play with the language. So now they call them system involved people. Okay. It's kind of like you're no longer a garbage man, you're a sanitation engineer.
Gotcha.
So these are considered a protected class in New Jersey. Okay. And I'm going to show you how. I'm not just making this stuff up, but these aren't my words. These are their words. Okay. Here's a little chart of this stuff. We don't need to study this chart or anything, but let's go on to the next page. So New Jersey law against discrimination forbids refusing to sell, rent, lease, assign, or sublease as a means of discrimination. For licensees refusing to offer property or to negotiate transactions as a means of discrimination or lying about the availability of property. Changing the terms of real estate transactions or offering special facilities or services to any persons as a means of discrimination. Or being involved with any expression, direct or indirect, of any limitation based on discrimination. That includes statements, advertisements, publications, signs, rent applications, purchase, lease, or records of inquiries. And the only exceptions that apply to that are rentals that allow rooms, apartments, or flats in certain types of housing to be restricted to members of one sex. I guess like in college dormitories and stuff like that too, you know. Religious-based organizations to discriminate based on religion, and an owner-occupant to discriminate except for race in the rental of a duplex or over/under in basically a two-family house where the owner lives in the other unit. Note these exemptions are similar to those that are under the federal laws. New Jersey, however, does not contain a federal exemption for homeowners selling their own homes or when a broker is involved. There's never an exception for race, whether a broker is involved or not, just like under the federal law. So at a glance, I put together this little chart here for you. It makes it easier to understand what kind of property is covered under which law. All right. The Civil Rights Act of 1866 covers all property. That's when President Lincoln freed the slaves and said that everybody has the right to own all kinds of property, personal or real. And the Federal Fair Housing Act of 1968 only covers residential property. Housing, it's got the word housing there, that's residential property. It doesn't cover personal property or commercial real estate. And the New Jersey law against discrimination covers all real estate, not personal property. Okay. That makes it a little bit easier to study this chart, right? Did you snap a picture, or you want to snap a picture? Or?
I snapped a picture.
Okay. Okay, so now on page 75, block busting and record keeping. Did you get this down yet? If not, please do.
Page 75.
Mm-hmm. It's towards the bottom of the page.
Yeah,
block busting and record keeping.
Yep, I got it here.
Right. So
good.
If you get 3 or more listings on one block, in a period of time, I'm not sure, let me see, within a month, if you get 3 listings on a block within a period of time, or on the same street within a period of time, you're required to keep permanent records of what activities, how did you get those listings? What kind of prospecting did you do? Did you send out mailings? What the script was that you used when you called them or spoke to them if you were door knocking? Or calling people, just to make sure that you were not using some sort of a blockbusting tactic to try to get them to sell. And then the posters, you know, you have to have them displayed in your office. New Jersey has their own equal housing opportunity poster as well. But unlike the federal law that if it's not posted there, you're automatically guilty of discrimination, with New Jersey, it's just a fine of at least $100. And here's what that poster may look like, or one of the versions of this poster. which is also in the book, I believe. Yeah, it's on page 76. So enforcements of the LAD, page 77. Let's do these highlights. This is all the stuff that was that I had written on that one slide. Complaints brought under the LAD, you have 180 days, 6 months to file the complaint. The fines are for first, second, and third offense up to $10,000, $25,000, and $50,000. Complaints under the LAD are filed with the Attorney General's office, who investigates. And under the Fair Chance in Housing Act, that new add-on to the law against discrimination is up to a $1,000 fine for a first violation, up to $5,000 for a second, and 2 or more violations, up to $10,000 fine. If you discriminate against the ex-convict system-involved person, or dare do a background check on somebody and then turn them down.
Okay.
I had another statement I was going to make. I'm just trying to recall what it was, but I'm having all these brain farts this morning. Let's see, what is it here? Their chance in housing. All right, I'll remember it later. Oh, okay, I remember it now. What document do you need to give owners at the time of listing?
CIS.
No, at the time of listing. CIS is the first document you give to anyone you intend to do business with. But at the time you get a listing dealing with discrimination, what's the document called under New Jersey law that we need to give to the owner? It's the Attorney General's it's the Attorney General's memorandum about the laws against discrimination. So on exam, you'll probably get a question that'll ask that, you know, what is the document that you need to give to owners at the time you get a listing regarding New Jersey discrimination laws? And it'll be either the Attorney General's memorandum, the LAD, the law against discrimination, or some other options. Okay, now I remember when I was in your position taking these classes, and I took my notes, and I took a lot of notes, and I was confused as hell because now I'm reviewing my notes and I'm studying them, and I'm like, oh my God, the LAD and the Attorney General's memorandum look like they're the same thing. Hold the phone. The LAD is the law against discrimination. You don't give people the law. You give them the document, the Attorney General's memorandum, which talks about the law.
Okay.
Just to clarify it, okay? Because I know I was in that position. I was studying this and I was pulling my hair out. I was like, she is driving me nuts. So the Attorney General's memorandum is the document you give to the owners at the time of listing. The LAD is the law. You don't give people the law. You give them the document that talks about the law. All right, you got all these highlights?
Yes.
Okay. So continuing with also those notes that were on that one slide is you'll highlight this as well. The copy of the Attorney General's memorandum against discrimination must be given to the homeowner at the time the property is listed, the point that I was just making. Salespeople and brokers must refuse listings when an owner tells you that they have an intention to discriminate. So what do you do if somebody tells you that they don't want you to show properties to these people or those people when you get a listing? You turn down the listing. You don't explain to them discrimination is wrong, and if they see the lights, then take the listing. You're supposed to just walk away because who knows what's in their heart, what they're going to do, and they can end up getting you in trouble. Okay, let's actually go over this Attorney General's memorandum now, which starts on page 78. As you can see, it's got the seal of the great state of New Jersey up here. And it's coming from the Office of the Attorney General, Department of Law, Public Safety, Division of Civil Rights. It kind of looks like an email, right? To, from, date, subject. Well, who is it to? Property owners. So who do you got to give the Attorney General's memorandum to? Property owners. When do you give it to them? At the time of listing. And what is it about? Housing discrimination laws. Okay, so let's move on. The New Jersey Real Estate Commission, the REC, requires every licensed broker or salesperson with whom you list your property to give you a copy of this notice. And the purpose is to help you comply with New Jersey law against discrimination, which we call the LAD for short. And the Fair Chance in Housing Act, that new addition that they effective January 1st, 2022. So let's actually read about this LAD now. Under the LAD, it's illegal to discriminate against a prospective or current buyer or tenant because of their actual or perceived religion, race, religion, national origin, nationality, ancestry, pregnancy or breastfeeding, sex, gender identity or expression, sexual orientation, familial status, which is defined as having care or custody of a child under the age of 18 or being pregnant. I actually had that as an issue one time. Disability, liability for service in the armed forces of the United States, marital status, civil union status, or domestic partner status. It's also illegal to discriminate against a prospective or current buyer or tenant because of any source of lawful income to be used for rental or mortgage payments. And it's illegal to make, print, or publish any statement, including print advertisements or online postings, expressing any preference or limitation or discrimination based on any of these protected classes. So there you go. In New Jersey, we have a lot more protected classes. And even if you don't fall under any of these protected classes, if somebody thinks that you're a protected class, you just became a protected class in New Jersey. How about that? So the LAD applies to a wide range of activities, whether it's advertising, selling, renting, leasing, subletting, assigning, or showing property, including open land. And here are some issues that frequently come up when enforcing the LAD. Now, I like these newer versions. See, the real earlier versions of the law, the Attorney General's memorandum that came out, only gave this guide. It was like a one-sided page, one one-page document that said that homeowners have to follow state and federal laws, and your agent will guide you towards about it. And we had to explain to people, oh, you can't do that. That's illegal. You can't do that. That's illegal. That's discriminatory. And people wouldn't believe us. So then we were like banging our heads against the wall trying to explain to people. I've had people where I told them, well, you can't do that. That's discriminatory. And the guy was like, oh, you'll say whatever you want. You just want to earn a commission. So I like the versions that actually spell out some of the more common issues that we come across. And so here are, as you can see in the bulleted list, here are some of the common issues that we've come across. The prohibition of discrimination based on source of lawful income means, for example, that a landlord cannot reject a prospective tenant because they intend to pay with subsidies or vouchers provided by federal, state, or local rental assistance programs, including Section 8 housing choice vouchers, COVID-19 emergency rental assistance programs, state rental assistance programs, or TRA, eviction prevention program, or unemployment benefits, child support, alimony, or supplemental Social Security. A housing provider cannot advise a property, advertise a property in any way that discriminates based on their source of lawful income, including any postings or advertisements that state directly or indirectly a refusal to express or place limitations on those vouchers or subsidies. Like they can't say no Section 8, or we don't accept TRA, or this property is not approved for Section 8, because the properties need to be approved for Section 8. But trust me, they're not that picky. They'll approve any property for Section 8. And Section 8 will pay the money. It's a direct deposit, so you don't got to worry about collecting the rent. Now, Section 8 is a subsidy. It's a rental subsidy for low-income people. So sometimes it pays all the rent. Sometimes it pays most of it, and the tenant only needs to pay a small portion. Like, I've had it before where the tenant only had to pay $25 of the rent out of their pocket. And then they didn't need to do that.
Oh my goodness.
If they don't do that though, then they're not paying their rent. And now technically you could evict them because they're not paying their rent. Even though you're collecting the money from Section 8, the whole rent's not being paid. The tenant, it's a subsidy. The tenant's still not paying their rent. It's only $25 out of their pocket and they're still not paying it. They can be evicted for that. So this property is not approved for Section 8, violate the LAD. In addition, housing providers must calculate any minimum income requirements or financial standards based on the portion of the rent that comes out of their pocket, not the entire rental figure that may be getting subsidized. Now, the LAD prohibits bias-based harassment in housing, including sexual harassment. So if a tenant's being subjected to bias-based harassment that creates a hostile environment, and if the housing provider knew or should have known about it, the housing provider must take reasonable steps to stop it. That includes harassment by other tenants or by housing providers' agents or their employees. A quid pro quo sexual harassment, for example, is where a building superintendent demands sex or sexual favors as a condition of making necessary repairs is also prohibited. No duh. Well, something you think may be common sense for some people may not be so common. Check this out. This is in Elizabeth. Here's a guy that owns all of these properties and then some. He was found guilty of, he had charges, he's been brought up on charges. And this is, I think, 2000, and was this?
These buildings look very familiar. I've seen them, definitely.
I actually know somebody that lives in this building. I know, I used to be friends with a girl that lives in this building. And I remember sometimes I'd go there to pick her up and I'm beeping a horn. I'm like, what the hell's taking you so long? And she's like, oh, I got trapped in a hallway by my landlord. He's such a freaking perv.
Oh
Well,
my God.
now I know. So
wow.
Federal housing authorities have filed a lawsuit accusing the city landlord who rented low-income residents of by demanding sex from residents on multiple occasions in exchange for assistance. The sexual harassment complaint filed by the Department of Justice in the U.S. District Court of Newark named Joseph Santeni, who authorities said owns numerous properties in and around the city of Elizabeth, ranging in size from 4 to 100 units. Around Elizabeth, let's see, Centeni receives about $102,000 every month from federal housing choice voucher programs and Section 8.
Wow.
You make that much money, that's just in the money that you're getting from Section 8 every month. And you got to harass women like this?
I am prostitute.
I mean, how pathetic does this guy got to be? You can't get play. You got that much money and you can't get any play. Come on, man. Look, the lawsuit alleges that since at least 2005 until last year, he engaged into severe, pervasive sexual harassment that included demanding sex in exchange for helping residents stay in their housing or receive rental assistance. Authorities also allege he threatened to evict tenants who rejected his advances and also demanded sexual favors for prospective tenants. Can you imagine? You're just checking out the place to possibly move into and the guy's demanding sex from you. Is that how crazy?
That's crazy.
Yeah, so these are a bunch of the properties that he owned in Elizabeth. All right. Now, what about this? Here's an example, a little news story I'm going to show you. Now, here's my little commentary. While it's disgusting and understandable to be uncomfortable living there, knowing things like this are happening, does someone who enters your apartment and then masturbates in your fiance's panties, does that constitute a crime of sexual harassment? Has the landlord's employee sexually harassed anyone? Did he have the legal right to be in their apartment? Can a landlord enter an apartment without the permission of the tenant? And my answer to that is no. They can only enter without prior permission. They can only enter without prior permission, except in the case of emergencies like, well, actually, that's the only time they could enter without prior permission, is in the cases of emergencies like gas leaks, flooding, etc. Otherwise, it's breaking and entering. It's an unlawful breaking and entry, and you can file charges against the landlord or their workers if they use their passkey to get into your apartment without your permission. They need to get your written permission, or they need to get your prior permission first, or at least set up an appointment, letting you know in advance. Check this out.
Top story tonight, a Hoboken couple says their privacy was violated. Their bedroom security camera caught a maintenance worker going through their things.
But it's what they touched that has them still uneasy. News 12 New Jersey's Erica Such joining us in the newsroom with more on this story. Erica. The couple tells us they purchased this security camera to just watch out when anyone was in their apartment, but never expected to capture an employee of their building going through their underwear. Take a look.
It said there was a notification for motion, so I checked it.
The Rivington resident Alex Sacchetti says he was at work just a few weeks ago when his security camera in his bedroom captured moments a maintenance worker did something out of the ordinary.
And I started watching, and the man was, going towards the dresser. I was like, wow, that's strange. And then he opened it. He was going through my fiance's underwear. And, after I watched the entire event, there was potentially other lewd acts that took place, but mainly just going through my entire apartment.
The worker is seen checking the bedroom door, closing it, and turning off the lights before going into the corner of the room.
You have to set the mood first, I guess.
Sacchetti says he quickly called management and alerted them. That's when this moment shows the man looking at the camera when he answers his radio call to leave the unit.
It was pretty much your whole privacy is violated.
Sacchetti says his fiance has been so upset by the situation, she's staying elsewhere for now. They filed a report with Hoboken police, but were told this.
He had the right to be in here, and apparently anything that took place is...
The two have been back and forth with...
I would have stopped right there and demanded to speak with the chief of police or some higher officer, because he did do something illegal. He entered without their prior permission. Landlords' employees cannot just enter somebody's apartment unless they said that, we're going to be entering to do pest control or spraying of the apartment, or we're going to be doing maintenance, and they arranged it in advance, and he knew they were going to be in there. But it doesn't sound like he knew that they were going to be in there, and that this guy just came in on his own, started rummaging through the underwear drawer, and then playing with himself in the corner of the room there. That is very illegal. And I'll show you where that's illegal when we look over the tenant's truth in renting booklets that specify what the laws are on this. I've had this issue a lot with landlords, mainly not so much with the big apartment buildings like this, but with maybe 2-family houses. I had one friend who she was looking to buy a house with her boyfriend. They were getting married. They were going to buy a house, and the place that they were renting, the apartment, the building, the house, the 2-family house was sold, and it was sold to some guy who was new to the country, foreign guy. And he's like, my country, this is my house. I could do whatever I want, And they're like, well, you're not in your country, buddy. This is my apartment. You're not allowed into my apartment. It's my house. I could do whatever I want. She told me a story where the day before something happened, where she got out of the shower and she came in the living room, and her landlord was standing in her living room when she got out of the shower.
Oh my God.
Yeah. I mean, I'm her boyfriend. I would kick the crap out of him right there. I forget about the cops. I'd be kicking the crap out of them, teach them a little lesson, But they're like, we also set up security cameras because there's a 2-car garage that has no wall separating the units. And, so we can look at our stuff, and he's rummaging through our boxes and going through our stuff because it's his house and he could do whatever he wants. Yeah, but he's looking through our stuff. It's ridiculous, So we need to get out of there quick. So, I helped them find a house by searching for something, and they bought a house, but this is not that uncommon, where people's renters' rights get violated all the time by people like this.
Equity Apartments, who owns the complex, but says their responses have been lacking empathy.
There's been some outreach from some sort of manager or something. I'm not exactly sure. But as far as oversight or, hey, so sorry this happened to you, like none of that.
And while this situation still leaves him uneasy, Sacchetti says it's a warning for others.
People here or elsewhere at buildings should just have some sort of surveillance to fall back on.
And the couple tells us they're hoping to switch apartments in the near future. We did reach out to Equity Apartments for comment, but did not hear back. In the newsroom, Eric.
What good is switching apartments going to do? You know, I demand that guy's fired, you know, and I would sue them, you know, get out of there, go to a different building, you know, that's crazy, you know. But this guy here, the boyfriend, the fiance here, he seems kind of lackadaisical, not like he seems kind of wishy-washy with, you know, well, there was some kind of, I don't know, outreach, you know. I'm like, damn, dude, I'd be all over. I'd be yelling and screaming, fussing, and bringing up making up a hell of a storm if that happened. That's crazy. Yeah.
A little calm.
Can you blame his fiance from moving out after that happened? You know, jeez.
Right.
I mean, normally you get up in the morning, you know, you go to your underwear drawer, you pull out your underwear, you figure you could put them on because you know they're clean. You know, this guy's over here doing God knows what in the corner with them, and now you're going to be putting them on. Oh my God.
Right.
So the housing provider must reasonably accommodate tenants with disabilities. That include, this is talking about those emotional support and guide dogs. They need to provide what we call that reasonable accommodation, even if they have a no pets policy. And a no pets rule cannot be enforced against a person with a disability who has a service or guide dog, or charge an extra fee for them. Landlords must permit a tenant with a disability at the tenant's own expense, this is important to know, to make reasonable modifications if such modifications are needed to give the tenant equal opportunity to use and fully enjoy the dwelling. Like if they need to put a wider door in, or any gadgets to help them get out of a wheelchair and put them on the toilet or in the tub, or if they need to put in ramping, you know, things like that. But at whose expense?
Tenants.
The tenant's expense. Now, can the landlord require the landlord to put the property, or can the landlord require the tenant to put the property back into the same condition that it was in when they got it, if they make these modifications? Not unless
I think so.
Not unless it would cause a problem for future tenants to fully enjoy the premises.
Okay.
So look, if you had somebody that had to put in a wider doorway to accommodate a wheelchair, is that going to be a problem for future tenants? No, they probably prefer it because they get their furniture in and out a lot easier, right? So that's not going to be an issue. The landlord can't require them to put that narrower doorway back in. So the LAD prohibits discrimination based on familial status as well. I had an issue with this one time in Roselle Park. So, for example, discrimination against families with children under the age of 18 and pregnant women. Landlords similarly cannot use unreasonable occupancy restrictions to prevent families with children from moving in. In Roselle Park once, I had a couple that had 2 children, and she clearly had one on the way, you know. So I'm showing them a condominium that was for rent, and the landlord had to meet us there to open the door. And, you know, I let the clients walk in first, and then I walk in, and then the landlord grabs me by the arm, and he's like, I'm not renting to them. And I was like, what? I was like, lower your voice. I was like, what? And he's like, I'm not renting to them. He's like, I'm not going to get in trouble. He's like, do you see her belly? She's going to pop any day now. So I kind of like pushed him in the other room. I was like, what are you talking about? I was like, lower your voice. What are you talking about? And he's like, she's going to pop any day now. I'm not going to get in trouble for renting to too many people. I was like, how would you get in trouble? And he's like, well, Roselle Park has an ordinance, no more than 2 people per bedroom. This is only a 2-bedroom apartment. There's already 4 of them. And she's going to pop any day now. That's how he kept saying it. She's going to pop. She's going to pop any day now. I was like, well, first of all, that baby's not here yet. So you can't count that baby yet, you know? And even when she does have the baby, you can't kick her out just because she had a baby. He's like, well, you're going to say anything you want. You just want to earn a commission. I was like, dude, listen, talk to your own realtor first, or better yet, call an attorney before you say one more word to me about this or to them. Because if you deny renting to them because she's pregnant, you're going to get hit with a lawsuit so fast it's going to make your head spin. I caution you to use your words wisely for what you say from now on. You know, contact an attorney before you do anything, you know, and he did. And my clients wanted to rent, so he contacted his attorney, and his attorney said I was right. You know, he said that, yeah, that baby's not here yet. You can't count that baby as an occupant. And even after the baby's born, you still can't count an infant as an occupant until they reach 24 months of age. So 2 years. So, and that's all they needed. They just wanted to rent for a little while so they could save up enough money for down payment to buy a house. So that it ended up working out good for them, but they don't know what I had to deal with this guy. You know, I wanted to make the home shopping experience comfortable for them, not knowing that they had a landlord like that, but wow, the stuff that comes out of people's mouths sometimes can shock you, So selectively inquiring about or requesting information about documentation of a prospective tenant's or buyer's immigration or citizenship status because of the person's actual or perceived national origin, race, or ethnicity, or otherwise discriminating on such a basis is a violation of the law. Yeah, of course. You can't just look at somebody and be like, yeah, you look like a foreigner. I need proof that you belong here, Obviously, that is discriminatory. We're a melting pot here. We got people from all over the world that maybe are citizens here, let alone the fact that this is created and this stipulation was put into place before our wonderful governor that we have here waved his magic wand and turned us into a sanctuary state that we're welcoming all illegals, So in the past, to rent to people, you can't knowingly rent to people who are here illegally in violation of immigration law. But now you got it a step further where the governor, made us a sanctuary state. And so illegal immigrants have rights to jobs and getting professional licenses and places to live now, too. So that's definitely, first of all, that statement is definitely discriminatory without a doubt. But even with the former laws, they don't apply or with the federal laws, I guess they don't really apply here in New Jersey. It's amazing that they're not being enforced on the federal basis. But then again, it's look who's president, As explained in the U.S. Department of Housing and Urban Development's April 2016 guidance documents. That's that guy that Obama appointed in HUD. Because of widespread racial and ethnic disparities in the criminal justice system, blanket policies that make all individuals with any prior arrest or criminal conviction ineligible for rent violate the LAD and the Federal Fair Housing Act because they have a disparate impact based on the race or national origin and are not supported by legitimate business necessity. Sure they are. They committed a crime. Has nothing to do with their race. See, they're basing this on a false narrative that because there's not an equal number of people in prison based on their race, it's discriminatory. It doesn't even take into consideration the fact if they actually are guilty of these crimes and posing a danger to those landlords or their kids who may rent to them. And housing providers may not use criminal history as a pretext for intentionally discriminating based on race or national origin. Now, for example, by applying a criminal-based restriction against a Black housing applicant, but not a white housing applicant. Okay, see, now they throw in this kind of a statement to try to calm you down from blowing your lid. Oh, yeah, you can't do background checks on Black people, but not on white people. That's a given. That's obvious because that's racist. But they're also saying that even if you do apply them neutrally across the board, you can't still deny rental to somebody who is a convicted criminal because the criminal justice system is racist, because there's not an equal number of people in prison based on that 2016 HUD guidance report. And look, it could still be read into that I'm reading too much into this. So let's continue reading. I'll prove that it's not just me. First, let's look at and highlight right here on the LAD itself. It shows you if you discriminate and you violate the LAD for a first offense, up to 10,000, up to 25,000, up to 50,000 for 3 or more violations. Okay, so first violation, second or third. Okay, up to. Those are the criminal penalties for violating the New Jersey law against discrimination. We already highlighted that. This right here is actually in the Attorney General's memorandum. I guess you don't have to highlight it on the form itself. This is just me doing that. And where would that be even? That would be on page 80 under penalties. And there are other remedies for victims of discrimination where they can recover economic damages related to the discrimination. Like if they were denied rental and then they had to find another rental elsewhere and pay a higher rent, they could file a complaint against the landlord, and now the landlord would be responsible for paying that tenant's difference in rent because you denied renting to them because you discriminated against them. You would have to pay the difference in their rent where they have to pay a higher rent elsewhere. They could also get damages for emotional distress, pain, and humiliation. In more egregious cases, a victim could also recover punitive damages. And this is pertaining to us. You, the broker, and the salespeople with whom you list your property must transmit to you every written offer they receive on the property. How soon?
24 hours.
Yes. And the broker and salespersons are licensed by the New Jersey Real Estate Commission, and their activities are subject to the LAD, as well as the general real estate laws of the state. What are the laws of the state referred to as? Title, the numbers, Title 45, Chapter
45?
15, 4515. Okay, so it's Title 45:15, Title 45, Chapter 15. And the Commission's own rules and regulations, which we call the Administrative Code, or Title 11, Chapter 5. Okay, so those two you will need to know for exam. They will come up. Title 11, Chapter 5 is the Administrative Code. That's the Real Estate Commission's rules. And Title 45, Chapter 15, those are the New Jersey statutes. We went over them the first day, the first page. Okay, so you already have you already have the notes. Don't bother writing them down again. You got them there already. You just got to study them a bit. And then the, let's see. The broker and salesperson must refuse your listing if you indicate an intent to discriminate based on any of the prohibitions in the LAD. And the LAD does not apply to the rental of one unit in a two-family dwelling if the owner occupies the other unit, or rooms in a house of a one-family house where they're only renting out a room. A religious organization can give preference to people of the same religion, and housing for older persons, it's not discriminatory against the familial status requirement because it's housing for seniors or 55 plus. Now let's get into that fair chance in housing again, the stuff with the criminal stuff. I told you, don't take my word on it. Let's now read their crap about this. So the FCHA prohibits providers from asking about the rental applicant's criminal records on an initial application for the rental, or otherwise considering an applicant's criminal record in any way until after they made them a conditional offer to the applicant to rent. They agreed to rent to them with limited exceptions as required under the federal law. And the goal of the FCHA is to ensure that formerly incarcerated and system-involved people, see, I didn't soften those words, they did. That's another way of saying ex-convicts, have fair access to housing around the state. And nothing about the FCHA requires landlords or housing providers to consider a person's criminal record. Yeah, of course. Of course, you don't have to consider somebody's criminal record, but if you wanted to, that's when they're coming down on you. If a housing provider does review a applicant's criminal history after that conditional offer, specific restrictions apply. A housing provider must conduct an individual, a housing provider must conduct an individualized analysis of an applicant's criminal record and may only deny housing if withdrawing a conditional offer is necessary to fulfill a substantial, legitimate, and non-discriminatory interest. And here are some of the specific requirements for housing providers under the FCHA. Housing providers are prohibited from asking about applicants' criminal records until after they made a conditional housing offer, except for convictions of drug-related criminal activity for the manufacture or production of methamphetamine on the premises of a federally assisted housing, or if the applicant is subject to a lifetime registration on a sex offender registry. Even after a conditional offer, a housing provider may not consider arrests or charges that did not result in criminal convictions, expunged convictions, convictions erased through executive pardon, vacated or otherwise nullified convictions, juvenile delinquency stuff problems, or sealed records. Okay, that's a given, because they're supposed to be hidden from the public. But check that out. You could deny them if they were running a meth lab in a federally assisted housing. But if they were running a meth lab in your mother's house that she was renting out to them, you can't consider that. I don't get it. Why? Politicians carve out exceptions for themselves. So if a housing provider chooses to consider an applicant's criminal record history after a conditional offer, they may only consider this. Check this out. You need practically a law degree to figure this out. Convictions for murder, aggravated sexual assault, kidnapping, arson, human trafficking, sexual assault, endangering the welfare of a child in violation of this specific law, convictions for any crime that requires lifetime state sex offender registration, only if it was a first-degree indictable offense or a release from prison for that offense within the past 6 years. Or if it was a second or third-degree indictable offense or release from prison for that offense within the past 4 years. Or if it was a fourth-degree indictable offense or release from prison for that offense within the past 1 year. So you practically need a law degree to know this stuff and be able to figure out what kind of criminals you could deny rental to. Otherwise, you're discriminating against them. So even if they were in prison, but they were released from prison, depending on the degree of their offense and when they were—
Should I memorize this?
No, no. You don't need to study or memorize. Okay. You just need to know about the general thing, the workings of it, that when doing background checks, it can only be based on a conditional rental. So you got to offer them renting first, and then conditional. I don't know if they'll have any questions on that in particular, but just be aware of the FCHA. I'm sure they'll have some kind of question on it. What is that fine? What was it? $1,000 for the first offense if you violate their rights, and up to 5,000. Was it for the
10, 25, and then 50?
No. For the FCHA.
Oh.
Where was that?
It's so much to study.
Oh, here we go. You have $1,000 for a first violation under the Fair Chance in Housing Act, $5,000 for a second, and $10,000. So it's 1, 5, and 10 for the FCHA. Just for violating the state's discriminatory laws, it's 10, 25, and 50.
So that would be 1,000, 5,000, and then 10,000, right?
And that's for violating the Fair Chance in Housing Act, which deals with
FCHA.
which renting to criminals. Yeah, violating the criminals' rights. The ex-convicts' rights. Oh, I'm sorry, the system-involved people's rights.
That's so ridiculous.
You said
Pisses
it.
me off.
I'm there with you, in case you haven't noticed. Now, for convictions that can be considered as a reason not to rent to them, a housing provider has to conduct an individualized analysis and document your process that you're going through to deny them rental. You have to list the nature and severity of the offense that was committed. You have to note the applicant's age at the time they committed that offense, in case they were a minor, I guess. How recently the offense occurred, and any information the applicant provided in their favor since the offense. I ain't do it. If the offense happened again in the future, whether it would impact the safety of other tenants on that property, and whether the offenses happened on or was connected to the very property they're trying to rent now again. So basically, they were running a meth lab in your house, they were in prison, and now they got out, and then they're coming back to you to rent again. I guess in that event, they could, it doesn't have to be in a federally related facility. Now, if the housing provider intends to consider somebody's rental criminal history as provided under the FCHA after that conditional offer, they cannot accept an application fee before disclosing that fact to the applicant and offering applicant an opportunity to provide evidence of any inaccuracies in their criminal record. I guess they don't have to prove it. They could just say, I ain't do it. Other evidence of rehabilitation or mitigating factors, I guess you need to consider that I served my time. And this requirement can be fulfilled using this model disclosure statement on this website. But hold on a second. That sounds like there's some kind of a form you could fill out and it'll tell you whether you can rent to them and make it a lot easier, right? No. Because if you click on this link or this link, you know what it shows you? It shows you this. The same thing that we just went over, which is you need a law degree to figure it out. That's all it takes you to. So this is pretty much nonsense. All right. So if the housing provider utilizes a vendor, an outside vendor, to figure it out for them, to do those background checks for them and decide who they're going to rent to for you, because it's kind of complicated. Well, under the FCHA, New Jersey's law, you as the property owner are still responsible if they fail to follow the state's guidelines on this law. You're still responsible for not renting to them or discriminating against them because you didn't rent to them, because you didn't follow the state's rules or guidelines, even if you use an outside company to do the background checks for you because you couldn't figure it out. How crazy is that? I hired a lawyer to figure it out for me. The lawyer couldn't figure it out and they screwed up. They didn't, so I'm still responsible. Forget about the fact that you tried to be in compliance and hire somebody who knew what they were doing to try to figure it out and so that you could follow the rules. Our politicians hold us to such higher standards than we hold them to. Housing providers are prohibited from discriminating against those with criminal records. Oh, so they are a protected class. So no matter how much they say they're not a protected, criminals are not a protected class, right there, they just said they are. Housing providers are prohibited from discriminating against those with criminal records. How effed up is that? In any advertisement, notices, or publications. They also can't require applicants to submit to drug or alcohol tests. Of course, we don't even do that when we give them benefits, when we give them welfare or other kinds of benefits. Right? Or to provide information from treatment facilities. Remember, because People in drug treatment programs under federal law are considered a protected class because it's an illness, right? But those who are current drug abusers that aren't even seeking treatment, they're not considered a protected class under federal law. But under the New Jersey law, they are. So if you violate the FCHA, you can be subject to a $1,000 fine for the first violation, up to $5,000 for second, and up to $10,000 for 2 or more violations within 7 years. If you want more information, you go to their website or call them. You're probably better off calling them, and then you'll probably still get nowhere. Because I've spoken with these people. I've spoken with these people at the mandatory seminars that instructors have to go through when teaching this crap, and it's nonsense the way they explain it. They fumble with the logic. You try to get them to explain it, and they're pretty much like, well, that's the law. That's their answer. Well, the politicians passed it, and that's the law. We need new politicians. That's what we need. All right. And then now on these newer attorney general forms, the broker or salesperson needs to print their name and sign, and so does the property owner. So they can hold us all accountable. All right. Other provisions. Okay, this is just some more nonsense, you know. According to New Jersey law, you know, you can't refuse to rent to people of the same sex. Obviously, that's sexual harassment based on their sexual preferences or whatever. You can't refuse to rent to gay people and stuff like that. If it's illegal, it's illegal to their sexual harassment. A lease can't provide, it'll become null and void on the birth of a child. And a facility does not cannot admit that does not admit pets has to allow a guide dog. You know, people with illnesses are protected under the you know, protected class of you know, what do you call it? The health. What is it called? What is it called? What is it called? The protected class, disability, under the disability status, AIDS, COVID-19, any of that, it's considered disability. And you can't discriminate against Asian people because you think that Asian people are all responsible for COVID-19, which is just silly. We all know that the virus was created in China. That is true. That is a fact. But you can't go out there saying that Asian people are all responsible for it. Okay, because yes, that is nonsense. That's more of a agenda that was put out there in the media as they attacked Donald Trump over this stuff, you know. But look at this. It's funneled down to the real estate class in a book that we got to learn about this like it's a real thing. That's ignorant people that are just pushing that agenda, conspiracy theorists and such. Now, landlords are also allowed to enforce health regulations, limiting the number of persons allowed. You know, I had that issue in Roselle Park. The landlord said that the town has an ordinance, no more than 2 occupants per bedroom. Well, that's true. But landlords are allowed to enforce health regulations limiting the number of persons for any given apartment size. And it is, of course, always proper to accept or reject prospective tenants based on their ability to pay the rent. That's their income, and their likelihood in doing so, their credit rating. So you could always run their credit and check their rent and have certain guidelines that you use to rent to people. So instead of not renting to them because of their criminal background, you could not rent to them because they got a crap credit score and they don't make enough money to as you would like them to make. Okay, I guess you could use that as the reason behind it instead. But remember, if you reject somebody because of their credit rating, you got to follow the ECOA, the Federal Equal Credit Opportunity Act, and supply them with a free copy of their credit report from the 3 credit reporting agencies and a letter explaining why they were refused because of their credit. All right. And multi-unit apartment buildings that are 25 units or more, the facility management is required to keep a record of the racial compound of the tenants that are living there, so that they submit it to the state, so that the state can investigate if it seems like there's an unproportionate amount of one race of people living there versus another, or there's not enough of a certain minority group living there. It could be possible that they're engaging in discriminatory rental practices. That's why the state has a law that requires the apartment building owners with 25 or more units to report the racial composition of their tenants to the states. All right, let's talk about love letters. Let's turn it a little brighter. Let's talk about something very pleasant, love letters. Oh, no, they're not talking about that. Not that kind of love letter. But this is something I totally agree with. I always thought that this was pandering and it was low. It was beneath me to do such things, that a lot of real estate agents did this, and some of them still do. And I think it is, I think it's beneath your integrity to do such things like this. But you get real estate agents out there that like to get their clients to write these pandering love letters to the potential seller to try to get them to accept their offer over other offers. You know, oh, our family, we love your house so much. Let's, if you were to sell it to us, we won't change a thing. We'll love raising our family here. Like, first of all, that's such pandering. Why don't we submit an offer based on the price and the solid offer that you're making, instead of all the emotional stuff? That's why people hire real estate agents, to take the emotion out of it. And I hate this. I actually had a listing one time that I had a buyer, and my buyer had the highest and best offer for this property. And the seller did not accept it because somebody wrote a love letter like this and pandered to them, and it pulled on their emotional heartstrings. And I said, you're getting more money and better terms with the contract that I got here versus this person's. I mean, you hired me to look at it in an objective way. I realize that I'm going to have both clients here, but it's not about that. It's about, what are they actually offering you? They're trying to manipulate you emotionally. And now I've been finally vindicated, because those types of letters can also be deemed discriminatory. Let's watch the video.
Hi, I'm Charlie Lee, Senior Counsel and Director of Legal Affairs at NAR. As buyers compete in a hot real estate market, they are searching for ways to stand out from the crowd. One method being used is to send a love letter to entice the seller into choosing their offer. While a love letter may seem innocent, they can raise fair housing concerns and risk exposing both the real estate broker and their clients to legal risks. The Fair Housing Act makes discrimination illegal in the sale or rental of housing and prohibits making housing otherwise unavailable because of race, color, national origin, religion, sex, disability, or familial status. Many states and local governments have their own fair housing laws, which can include additional protected categories. The use of a love letter often presents fair housing issues because they often contain personal information about the buyer, such as their race and culture or traditions, as a way of appealing to the seller's emotions. Some buyers even go as far as sending sophisticated packages that include photographs and videos. For example, a buyer might send a letter with a photo of their family around a Christmas tree. As a result, the buyer has revealed their religion, which is a prohibited basis for a seller to base their decision to reject an offer. While it may not be the buyer's intent for the seller to use this information to discriminate, that is essentially the position that a love letter can place the seller. When considering that the information cannot be easily forgotten or unseen, a love letter may ironically cause the seller to be fearful of selecting the buyer's offer because of potential discrimination issues. Therefore, real estate professionals should advise their clients about the risk of love letters, and at a minimum, stressed the importance of avoiding including any information in the letter that could be used to legally discriminate. But of course, even a photograph of the buyers could lead a seller to give preference to a buyer or reject them based on race or other background. Fair housing is a high priority throughout the country, and states are closely monitoring the practice of love letters. In fact, just recently, Oregon enacted a law to take effect on January 1, 2022 that bans the use of buyer love letters. Here are some best practices to consider when it comes to love letters. At the outset of the relationship, speak to your client about the risks of buyer love letters and the potential fair housing issues they raise. Remind your seller client that an offer should be assessed based only on objective criteria, such as price and timing. If your seller client insists they want to receive buyer love letters, advise them to consult legal counsel and to document their decision-making process in selecting an offer. Avoid helping buyer clients to draft or deliver love letters. Be sure to warn them against revealing any personal information that could raise fair housing issues. Counsel them to focus on the characteristics of the home or other objective information. Lastly, help your buyer clients find other ways to differentiate themselves to win the property. Beyond offering more money, the buyer may consider offering more flexibility with the closing date, additional earnest money, or waiving other contingencies that may appeal to the seller. Thank you for watching this episode of Window to the Law.
So this Window to the Law series of videos that NAR created, you could actually use some of them like this one to send to your clients and put it like on a web page that you send, that you got set up of videos that they should watch and documents that they should read before they list properties or start searching for homes. It makes it a lot easier to do your presentations too, so you don't forget anything. And make sure that they go through them. So this one is a pretty good idea, you know, telling you not to do those love letters, or the sellers anyway. All right, here's another one. Mount Laurel. Mount Laurel is a town in New Jersey. Mount Laurel, New Jersey. New Jersey, a little brief history of our state. We're the third state in the nation. So when we were forming as a country, we were the third state admitted to the Union. Back then, we also had, we were part of what we call the Underground Railroad. Remember that in elementary school, learning about that term, the Underground Railroad? That's where former slaves or escaped slaves from the South escaped up to the North that was free, where they could live for free, or live freely. So we have the zoning discrimination laws, Mount Laurel 1 and 2. Well, Mount Laurel was one of those towns that the Underground Railroad ended up at. That was one of the ending points of the Underground Railroad. And then from that point, people then went everywhere else in the country to live, or some families actually settled there in Mount Laurel. So you have a history. Back then, there were no zoning laws or regulations. People can build houses out of mud if they wanted to. You know, there was no kinds of building regulations back then in the 1800s, 1800s. So what we had is a bunch of people that built houses close together. And so those houses were then passed on, the ownership of them through generations to their relatives. So what do you think? Those houses were highly valued? No, not really. If you got small houses built practically on top of each other, so close to each other, no, not really. And the town of Mount Laurel, New Jersey, they wanted to build their revenue so that they could improve their roads, their school systems, their infrastructure, their police, their fire, their you name it, their infrastructure, right, in their town. Now, where do towns get the money to do that?
Us.
Okay, well, how do they get them from us? From what?
Taxes?
From property taxes. Property taxes will pay for that. Now, what determines how much that the municipality can charge you in property taxes? It's based on the value of the property that's being taxed. So the town of Mount Laurel, New Jersey said, well, these houses are pretty cheap. We can't charge a whole lot in taxes on them. So how can we raise the revenue so that we can improve our infrastructure? This was their plan. And they said, we got an idea. Any new construction that's going to be done in this town will have to have larger lot sizes to build a house on so that they're not building small houses right on top of each other. So that sounds like a good idea, right? Okay, larger lot sizes in order to build a house anywhere in the town. Okay, sounds good. But they implemented it in a wrong way. It would be one thing if they said you need to have a 50-foot by 100-foot minimum lot size to build a house on. Instead, they went much larger than that. Now, I don't know what the exact size is. Let's just be ridiculous about it and say that it's 1 acre. You have to have a minimum of 1 acre of land in New Jersey to be able to build a house on it. So that's a big piece of property there, 1 acre. So people started moving in and buying 1 acre of land to build a house, started building mansions on them. Now, when you build mansions on it, you're bringing up the value of the neighborhood. You're also making that raw land even more expensive, effectively pricing poor people out of the town. That poor people wouldn't be able to buy the plots of land necessary to build a house on it if you needed a whole acre of land in an expensive area because the prices are going up now. So in 1971, the town of Mount Laurel, New Jersey, was sued by the NAACP against the town against Mount Laurel, New Jersey, for illegal discrimination against low-income and moderate-income persons through the use of something that came to be known as exclusionary zoning, because you're excluding poor people from the area when you effectively price them out of the area by requiring this larger lot size instead of a range of housing. So the court stated that all developing communities have to zone for their fair share of the region's need for low-income and moderate-income families. And in 1975, the court ruled that the poor may not be excluded from residential areas. So you can't just say, okay, well, we'll provide a range of housing, but the smaller lots will be in those commercial areas or on the outskirts, okay, of town. So that's what this court decision was. So the Mount Laurel 1 court decision was a good court decision because although I'm not going to say that the town of Mount Laurel, New Jersey, had it out for poor people and low and moderate income people. They just went about the wrong way. They had a good idea, but they implemented it in the wrong way. The lawsuit makes it sound like if I were just to read this paragraph, it sounds like Mount Laurel is this evil place full of rich people that want poor people to die and just disappear from the planet. But that's not the case. Let's give them the benefit of the doubt. This is actually the truth of the story here, if I'm giving you the backstory. They had a good plan, but they poorly implemented it. And the end result is they were discriminating, effectively pricing poor people and moderately priced people out of the area, moderate income people out of the area. So later on, so first court decision, Mount Laurel 1, good court decision. Now, Mount Laurel 2 is another court case. Another lawsuit came about in 1983. A second lawsuit filed by NAACP against Mount Laurel resulted in the courts providing specific guidelines for all developing communities. They said that all municipalities have an obligation to provide a range of housing. And by the way, the way that this is written is a little misleading because the courts did not provide specific guidelines. The courts only said that each municipality has to they have to create their own specific guidelines that they need to follow on how they're going to accomplish this goal. Otherwise, they may be subjected to fines and penalties. So let me ask you a question. If a court gave you as an individual the option of creating a bunch of specific rules that you have to follow, otherwise you could be fined for not following the rules, are you going to create a whole mess of them?
No.
No, that's silly, right? So even to this day, the majority of the towns in New Jersey never did this. There was no penalty for you not to do it. It just says the Mount Laurel court decision told towns that you have to create these guidelines and these specific guidelines that will how they'll restrict you and how you have to follow them to accomplish these goals. And if you then violate those guidelines, you'll be subjected to all kinds of fines and penalties. But they didn't say there were any fines or penalties if you didn't create them to begin with. So most towns never created them. Politics, so thorough, right? Let's see. So this was accomplished by allowing for higher density development. So in other words, allowing you to build homes closer together than normally allowed. A 20% set aside. That was an order that said that towns are required to keep track of all new construction. And for every 100 homes built, 20% of them, 20 homes, needed to be for low and moderate income people. Zoning for mobile homes, and a requirement that communities must cooperate with efforts to obtain subsidies. Subsidies is a dirty word for money. So the towns are required to try to get money from the state and federal government to help them facilitate this need for low and moderate income housing. And a panel of 3 judges was appointed by the Chief Justice of the New Jersey Superior Court to listen to similar cases where people are subjected to discrimination based on these rules not being followed. And they experience a hardship, therefore. Okay, so that's the basic rule there. Okay, so nothing was too specific in the Mount Laurel 2 court case. It just said that towns have to create their own specific rules of how they're going to accomplish this, and that they were allowed to create higher density developments than normally allowed. They had a mandatory requirement that they need to keep track of all construction that's being built and have 20% of it be set aside for low and moderate income housing. Now, because most municipalities throughout the state did not create the rules on how they were going to do this, people who go in and they apply for a permit to build something, if I want to build on a property that I buy, let's just say I want to build some storefronts, and above them I want to put some condominiums. I want them to be some nice luxury condos above the storefronts. And the city says, you can't do that. That whole area is only zoned for 1-family houses. And I say, really? Well, I did a little research and I found out that your community, your town did not create the specific guidelines that the Mount Laurel 2 lawsuit required you to do. So I'm going to take it to the panel of 3 judges to hear my hardship case that you're not allowing me to build my storefronts with my luxury expensive housing above it. Wait a minute. What was the purpose of the Mount Laurel court decisions? Wasn't it supposed to be for low income and moderate income housing? Wasn't that the intention of the law? Yes. But actually what happened is it created loopholes. So you got developers now going to towns trying to get permits to build projects that have nothing to do with low income or moderate income. And the town denies them because the zoning law that they created in their town does not allow them to build what they want to build there. So they'll go to they'll file a lawsuit against the town because the town never created the specific guidelines for the low income and moderate income. And because of that, they're allowed to sue the town to ignore their zoning laws. And this panel of 3 judges will agree with it and allow them to build whatever the hell they want, even though what they're planning to build has nothing to do with low income or moderate income housing. They're using it as a loophole to build what they want. And this is actually a lawsuit called Builder's Remedy. That's why I have that written there, Builder's Remedy. Builder's Remedy is what we call that lawsuit. So even today, Governor Christie, when he was governor, he actually, towards the end of his governorship, where he was already crap governor at that point, you know, and in his first term he was good, in his second term not so much. Towards the end, when he started running for president, he tried campaigning for president. Remember that Governor Christie tried doing that? He actually brought up to the politicians in the state, because politicians create the laws, not the governor. We have a body of politicians that debate laws and draft the laws and create the laws. When they agree upon it, then they put it upon the governor's desk to do the final signing off on it, just like the president does for laws affecting the nation. So he went to all the politicians in the state and said, listen, guys, these Mount Laurel court decisions are not accomplishing their goals. They've been in place since the 70s, and we're just not getting enough of this low income and moderate income housing being built in the most densely populated state in the nation. It's just not being built. I suggest that you guys, this law is full of loopholes. I suggest that you guys just do away with the Mount Laurel laws and sit down from scratch, write some new laws without any of the loopholes in them, so that we can accomplish these goals. And the day that you guys do that, I'll sign off on it. All you heard for the next 2 weeks in the news, because at this time he was already running for president, all you heard for the next 2 weeks in the news was Governor Christie makes a racist proposal to do away with longstanding protections for poor people and minorities, the Mount Laurel court decisions, you know, and that's how they worded it. You see how dirty politics is? That's not what he did. He was actually trying to fix the loophole that affects the housing for poor people, you know, to give them more housing. But it was worded in the media that he made a racist proposal to do away with long-standing protections for poor people and minorities. And when that's not at all what he did. So after that was in the media for like 2 solid weeks, not just in the local media, but in the national media, he threw his hands up in the air. He said, I give up, forget I said anything, I'll drop the topic altogether. Now, why did the politicians do this? Was it just to attack him as if he ever had a chance to be president? I mean, he wasn't going to be president. He wasn't going nowhere with that. So why did the Democrats attack the Republican Governor Christie over this? I think it was because they didn't want to do away with the Mount Laurel decisions. I think there's a lot of politicians in this state that are taking advantage of the loopholes, where they have family members or they themselves are involved in construction projects and development, where they're getting richer by ignoring zoning laws, being able to build whatever the hell it is that they want. Now, this is not just exclusive to rich people to do this, guys, or politicians. You can do this. Or if you have a client that wants to buy a property and build something, and then town says, no, you can't do that. It doesn't comply with our zoning ordinances. It's not zoned for that there. If you do some research to find out if your town created these rules about that the Mount Laurel court decision required them to do, and if they did not put them in place, because more than half of the municipalities in New Jersey don't have them in place. If you find out your town doesn't have them in place, you could sue, or you could tell your clients about it and let them sue the town under Builder's Remedy. Tell them that the lawsuit's called Builder's Remedy, and they could ignore the zoning laws and build whatever the hell they want. Are you familiar with Cranford at all?
I know of it. Yeah.
Okay. So the town Cranford, they have a train station over there, and across the street from the train station, for blocks, those were all zoned one family. Those were all one family houses over there. So a developer went in and he bought up all those houses on those blocks. And the story that I just told you was actually based on that. The developer went in, tried to get the permit to build these storefronts with luxury, expensive condominiums above them. None of it is low-income housing. And the town said, no, that's zoned for one-family housing. He sued Cranford under builder remedy laws, and the panel of 3 judges said, build whatever the hell you want. He actually built those storefronts with all those expensive condos above them right across the street from the train station. That's how that got built there. That was all zoned one family. Those were all one family houses at one point. This also happened in Summit. It's happening in a lot of towns. Don't believe me. Don't take my word for anything I'm saying here. Do a Google search. Type in New Jersey builders remedy lawsuits, and you'll see thousands of them will come up. So this is just not my opinion of it, and this is just not me giving my slanted view on it. I always tell people, don't trust but verify. Yeah, who knows? Maybe I've got a slanted political view that I'm throwing out there, or ideology. So don't trust me. Do your own research. Do it on Google, which Google's search results are even slanted, and you could still prove it using that. All right, so what do we need to know for exams pertaining to Mount Laurel court decisions? Well, you need to know this for exams. You need to know the term exclusionary zoning is a discriminatory zoning practice outlawed by the Mount Laurel court decisions, which discriminated against low-income persons, the poor. It says that low-income people cannot be excluded from residential areas. Okay, so basically you need to know these first 2 bullet points as a definition. That's what you need to know for exam. It will be on exam. And then that whole explanation that I just gave you, I wrote down here, builder's remedy, a lawsuit. I just put the explanation there of what I just verbally explained to you of what the real story is. Because if you were just to read that whole paragraph here, these 2 paragraphs on Mount Laurel court decisions, it sounds like Mount Laurel is a horrible racist town that hates poor people and minorities. But that's not really the case of what happened at all if you do a little research. Okay, moving on. Code for Equal Opportunity Standards of Conduct by Realtors. We pledge to offer equal services to everybody. And we often have partnerships with HUD and NAR to offer fair housing seminars and all kinds of education stuff to the public. And we do all kinds of community initiatives like cleaning up of parks and rundown areas to try to improve the communities and such like that. That's all that's about. All right. Now, implications for brokers and salespeople. We have to display that equal housing opportunity poster from HUD as well as New Jersey. We have to prominently display a sign stating that we don't engage in discriminatory practices, and your company should have a policy that's written saying to abide with these anti-discriminatory laws. We make proper responses when clients are searching for a home with discriminatory desires. So if you ever get a call from a buyer that says, hey, listen, I'm looking for a house, but I don't want to live by these people or these people, we cannot search for homes based on who lives in an area. So you should not even chime in on a conversation if somebody ever tries to start a conversation like that. Instead, just ask them, well, where exactly is that? We're in New Jersey. It's a melting pot. People are free to live wherever they want. So you tell me the area that it is that you want to live in, and I'll search for a home that meets your criteria in those areas. But I can't search for a home based on who lives in the area. And I've had listings before. Now, this isn't an often common thing here, especially in New Jersey. So, but I have come across before where I had a listing and people ask, well, who lives there? And I'm like, well, the house is going to be delivered vacant, so it doesn't really matter who lives there. And they're like, no. I mean, who lives in the complex or who lives in the area? I mean, people, I mean, what is your response going to be? So I say, people. I'm sure they're very nice. If you want to come down and talk to them and walk the neighborhood and see if it's an area that you want to live, let's make an appointment. You could come down. I can meet you at the property, open it up for you, show you the house, and then you could talk to the neighbors and see if it's a place that you want to live. Okay. Don't don't even enter into the conversation, guys, because you never, first of all, know who you're talking to. It could be an investigator that's trying to, we call these people testers. Testers are undercover mystery shoppers. They're volunteers that HUD trains on how to catch people who are not treating everybody equally, but are actually engaging in discriminatory actions and conversations. So they don't work for HUD. They're not employed by HUD because that would be entrapment. So these are people on some sort of a social justice a crusade, and they're taught by HUD on how to go about their activities. And then they go out there and they test us. They'll call you up on a phone, or they'll even meet with you to look, and they pose as buyers or renters, but they're not really buyers or renters. They're just wasting your time because they're trying to test you to see if you're treating everybody fairly and equally, and if you're engaging in discriminatory conversation or actions. So you never know with whom you're dealing with. So that's why it works. From my perspective, it pisses me off because you're wasting my time. My time is valuable. I'm not discriminating against anybody. I don't care what your color, race, religion, who you sleep with. I don't care. I see green, money. I want to sell you something. You know, I want to make money. I don't care who you are. You know, but that's my take on it anyway. So make proper responses when clients express discriminatory desire. So I've had people that called up before and said, well, who lives there? And I just gave the spiel that I just gave you. And but I've had instances where I've had so many that after a while I was like, ma'am, I can't discuss that. I could get in trouble for that. That could be deemed discriminatory. And I had this one lady one time, she's like, oh, no. You got me all wrong. Me and my husband, we're New Yorkers, you know, with that New York accent, you know, we're New Yorkers. We want a place that's more diverse. So who lives there? Ma'am, it doesn't matter your reasoning for asking it. I cannot engage in that conversation, period. Because I mean, you could just be saying that. I don't know.
Right.
I don't know who you are. It's illegal for me to enter into that conversation. I can't do it. You know, come on down. I'll show you the property. You could talk to the neighbors and look over the neighborhood yourself and see if there are people you want to live next to. I was like, but I can't get involved in that. You know, just leave it at that. Sometimes those conversations can be uncomfortable, not like they happen very often, but sometimes those conversations can be uncomfortable. I don't think they're uncomfortable because I'm not discriminating against anybody. I really don't give a crap. I see green, you know?
Right.
But you got to know how to talk to people, especially new agents, especially young people. They don't know how to get into that conversation, and they get kind of emotional. Sometimes they start like shouting or yelling at people. You know, don't do that. Or they get into this, what do I say? I don't know if I should say something. You just listen. If you go by the book and what the book's advice is, the book tells you to use conversation like this. Let me see. Okay. Well, these are some more things we're going over. We're going to go over reverse discrimination and what to say in advertisements. Okay. Now let me turn the page here. Okay. So we already have this highlighted on page 84. It says that in order to be found guilty of discrimination, guilty knowledge or specific intent to discriminate does not need to be proven, only the fact that discrimination occurred. So it doesn't have to, it may have been the furthest thing from your mind to discriminate from somebody. But if the end result was somebody was discriminated against, you're guilty of discrimination. That's how low the threshold is to be found guilty of discrimination. Now, on the same page, if we move down a little bit, a couple paragraphs, it says, here's your guidance as to what you should say if somebody calls up and asking you, well, I'm looking for a home that meets that I don't want to live by these people or those people. What do you say? Well, it says if a prospect expresses a locational preference for housing based on someone's race, the association's guidelines suggest the following response. I cannot give you that kind of advice. I will show you homes that meet your criteria, that meet your specifications, and you will have to decide which ones you want. But to me, that sounds kind of robotic. I like to have a way. You got to say it in a way that kind of flows. Hey, listen,
Yeah.
to be deemed discriminatory, I can't enter into a conversation like that. But I could set up some appointments with you. You tell me the criteria of the homes that you're looking for. Or if you know an area already where you want to live, I could show you homes in those areas. But I can't search for homes based on who lives in an area. That could be deemed discriminatory. I could lose my license for that. I could be fined for that. I'm just not going to go there. Okay. And I just tell people straight up like that. And then you usually don't have a problem if that comes up. Actually, when it comes to buyers searching for homes and discriminating like that, I had one guy ever in my 20 years, I had one guy ever that was like that. And he was like, yeah, I don't want to live by these people, those people, those people, those people. I was like, dude, you're moving to the wrong state. I was like, New Jersey's the smallest state in the nation. That's the most densely populated state. And we're a melting pot of people from all over the place. So you're moving to the wrong place. If you don't want to live by these people, or those people, you're going to be close to them. I was like, you need to loosen up or move somewhere else. I just have the conversation like that. And the guy was like, okay, so he was okay with it. And with my conversation way I did it. So he still wanted me to help him search for a home, and he would be telling me where he wants to look. Now, the next time he came to my office, and I found a bunch of properties for him in different areas, he came with his own laptop, and he's like, all right, yeah, that property looks pretty good. Where is it? And now he's looking through his laptop. He found some website that shows like the Census Bureau demographics of the composition of the people in that area. And he was like, oh, no, there's too many of those people. I was like, dude, what did I just tell you? I was like, don't do that in front of me. I was like, I don't want to be involved in that. Yeah. But I had one person ever like that. Okay. Now, reverse discrimination is a thing too. Reverse discrimination, it even has discrimination there in the word. It's a term where you're discriminating against white people, and it's kind of excused because some people today, if you ask them straight out, they tell you can't discriminate against white people. It's not discrimination. It's only discrimination when you're doing it against somebody, a person of color. You can't discriminate against a white person. White people are the devil. Well, you know what? You're an idiot. Reverse discrimination, we're all people, and reverse discrimination is a thing too. And there are a lot of lawsuits coming about where people were denied jobs because there are regulations put into place where they're trying to give more jobs to minority groups because, they want to make up for past wrongs or whatever. But I think we've reached a point today in our society that's been done already. I think that there is no more discrimination in workplaces and things like that based on these criteria. What we have, these affirmative action laws, they actually went to recently, I think it was last year, the Supreme Court ruled that those laws are unconstitutionally discriminatory and no longer needed. So giving people admissions to colleges or jobs based on their race and trying to justify it because we need to get more minorities in there and discriminating against white people and putting minorities above white people is not discriminatory. Well, it is. And the Supreme Court even found that. So now all of those affirmative action laws, unconstitutional, illegal. Can't do it anymore for admissions to college. Can't do it anymore for jobs. And well before they even did that last year, reverse discrimination lawsuits where people like firemen or police who have been waiting for like a promotion position based on their ability to do the job and their seniority in those doing those jobs, having the experience, were turned down because somebody else was given extra points because they were a minority, and that as the sole reason is discriminatory. And we see these lawsuits all the time now, especially right now where white people are being discriminated a lot. Now we get people, this is a hot button issue anytime we're starting to talk about this stuff. and it could be uncomfortable for some, but either way, it is what it is. It is discrimination. So reverse discrimination regulations are intended to preserve racial balance in given areas. But as we just studied, the complainant does not have to prove guilty knowledge or specific intent. So your intent does not matter. It's still discrimination. So sometimes local laws run counter to federal and state rules, posing the real problem for the conscientious licensee. So if you ever have a local law or regulation where a politician's trying to put some kind of rule in place that you need to favor a minority group ahead of another group like a white people based on their race, I suggest that you just treat everybody fairly and equally, ignore them and do your thing and hope that you don't end up involved in some kind of a lawsuit. Because this is usually politicians pandering to groups and causing these problems. All right. Treat everybody the same, fairly, and hopefully you got nothing to worry about. Hopefully. All right. Now, when it comes to advertising, what are the rules on advertising? What can be deemed discriminatory or not? Well, let's look at the category, the rule, what's allowed and what's not allowed. The first category is the race, color, or national origin. And the rule is pretty much the same all the way down for all the different categories. No discriminatory preference or limitation can be expressed. You're allowed to say things like master bedroom or good neighborhood. They're not considered discriminatory. And how racist do you need to be? You need to be one of these people who always have race on their mind to consider the term master bedroom a racist term. That's for people who are thinking back in the days of slavery where there was a master, you know. I mean, really, what an obscure term these days to be considering master bedroom a racial term. Master bedroom was never based on the slave master's bedroom. That's not where it came from. The master bedroom is the largest bedroom in the house that has a bathroom attached to it. Not every house has a master bedroom. A master bedroom is a bedroom that has a bathroom attached to it or in it. Okay, so it's not a racial term, it's allowed. Good neighborhood. I mean, come on, guys. So what's not permitted is things like white neighborhood or no French. When it comes to religion, no discriminatory preference or limitation. You're allowed to use terms like chapel on premises, kosher meals available, or Merry Christmas in your advertisements. And they're not considered discriminatory. Chapel on premises or kosher meals available. We're not talking about what's in the neighborhood. We're talking about, let's say it's a building, like it's a condo building, maybe a high rise, and they got a kitchen in there or something, or they have a chapel on the property. You're just describing features that are on the premises. You're not allowed to talk about things like this that are in the neighborhood, though, because that's a little bit different. Those are things that are not on the property, but things on the property like this, you're allowed to, and it's not considered discriminatory. You're allowed to use holiday greetings. Merry Christmas, Happy Hanukkah, Happy Kwanzaa, Happy Festivus for those who aren't religious, you know, whatever it is, you know, you're allowed to use these terms. They're simply greetings. And I don't know at what point we got so woke and turned ourselves into hypersensitive little babies that we get offended by everything. I mean, it used to be when I was growing up, you could say Merry Christmas to a Jew and they didn't take offense to it. They would say Happy Hanukkah and I wouldn't take offense to it, you know? I know it's a greeting, you know? Now, what's not permitted are things like no Muslims or nice Christian family or walking distance to synagogue. Now, this last one over here could be important to religious people, particularly Jews and Muslims. Because I think both of those faiths, they need to be within walking distance to their houses of worship on certain holidays or what have you. They walk a lot and they go to they can't drive, they can't use modern conveniences and stuff like that because of their religion. So it's an important selling point that they think, if it's going to be other Jews or Muslims that are moving there, to tell them that it's within walking distance to their synagogue or their mosque. Okay. So you can't use that term, no, because it's a synagogue is targeting Jews, a mosque is targeting Muslims. But what you could say in your ad is walking distance to houses of worship, and that's acceptable because it's secular. It's not targeting any particular religion.
Right.
That's more acceptable. Now, when you're talking to somebody, it's different than what you're putting in an ad. We're talking about advertisements here. When you're talking to somebody, if they ask you, is that a synagogue or is that a mosque? You could tell them. There's nothing wrong with having a conversation and speaking to people. We're talking about what you're allowed to say in advertisements. Now, when it comes to sex, no preference or limitation. You're allowed to say in-law suite or mother-daughter or female roommate sought. Why is female roommate sought? How come that's not discriminatory? Well, it's because somebody who's going to be living in the same apartment as you, you're just giving them their own bedroom in your apartment. They're living in the same unit as you. So if you're a female, you may be comfortable only with another female there, and you may feel uncomfortable with some old guy creeper coming in there. Oh yeah, I'd like to live there with you, you know. So yeah, it is acceptable to say female roommate sought, but if you're just renting out a vacant apartment, you can't just say females only. That's discriminatory based on sex. You're allowed to say in-law suite or mother-daughter because this is describing a feature of the house. It's a one-family house that's set up like a two-family house. So you can't rent out those units separately, legally anyway, because it's a legal one-family house that's set up like a two-family house. It's known as an in-law suite or mother-daughter. Both those things are describing the same thing. You're not allowed to say things like great house for a man. Why not a great house for a woman or other 52 genders they come up with, right? Or wife's dream kitchen. What is it, only for married people? Is it only for straight married people? You see how people would start attacking this if you put that in an ad? Why not just say dream kitchen or great house? Now, man cave and she shed, I use these terms all the time in conversation or when showing houses, but don't put them in an ad because you're going to get one of these hypersensitive people who are just blow their lid looking for a reason to sue somebody because I'm offended by everything. You know, what is a man cave? Well, usually it's when you set up the basement with a bar or a pool table or like a little movie theater so the guy can go down there, get away from the family for a few, do his thing and be with his boys and, it's his getaway to enjoy the place. So it's set up like a man cave. That's where the term comes from. Now, if in an advertisement you want to use some kind of a term to describe that, how about grotto? Ooh, that sounds expensive though, versus a man cave. So when somebody comes down, if you're talking to somebody or if you're showing them a house, you can say, yeah, it's set up like a nice man cave down there. That's one thing versus having it in an advertisement. Now, she shed is similar to a man cave, except it's like one of these HGTV concepts where there's a shed in the backyard, maybe it's got electricity, maybe even running water and stuff in there, and it's set up like her own little getaway for her, to do the same thing like the man cave would for him, so it's here, if we go to the next slide, here, have you ever seen this commercial?
Well, it finally happened, Zachary.
I
Somebody
don't
burned
think so.
my she shed. Nobody burned down your she shed, Cheryl. Well, my she shed's on fire. The she shed was struck by lightning. Zachary, is my she shed covered by State Farm?
Your she shed's covered, Cheryl.
You hear that, Victor? I'm getting a new she shed.
Look at that she shed, huh? Got a chandelier in there for crying out loud.
I need a she shed.
I need a she shed. That's
Well,
something, huh? Okay, so that's what a she shed is. Let's see. Now, disability, no preference or limitation. You're allowed to use terms like wheelchair ramps, walk to shops, walk-in closet, and you're not jogging path or walking distance to the bus stop or whatever, and you're not discriminating against people who can't walk. You're just describing features or distances, okay? That's not considered discriminatory. You are not allowed to say things like no wheelchairs or able-bodied tenants only. And why would you? You should always keep your advertisements positive. Try not to put negative terms or things that would turn people away. Try not using words like no, not, able-bodied tenants only. That's negative. Keep your ads positive. Look, I've had places that were not handicap accessible, but I left that out of the ad. Instead, I found a different way to put it in there. I had a 3rd-story condo unit, no elevator, no escalator, no way to put in ramps or anything because it was a winding staircase. So I just called it a 3rd-story walk-up. And I actually had a guy that called me up and said, is there an elevator in the building, or is there a way that I could put in ramps because I'm actually in a wheelchair? I can walk up maybe 1 or 2 steps, but I can't walk a lot because I'm pretty much wheelchair bound, but I can walk a little bit, but it's tough for me. And I was like, no, unfortunately, this is 3 stories of winding stairwells, and it's not really a room there to put in the ramps. And no, there's not an elevator in this building. But if you want, I could see if there's any units available for you on the 1st floor, and maybe we could show you those. And so because I didn't put something negative in there saying that it's not handicap accessible, I didn't turn the guy away. And I got a phone call from him making an inquiry when he saw a 3-story walk up, and he called up about it. We had a conversation, and I ended up showing him properties, and we ended up finding him a condo on the 1st floor. So I ended up selling him something. So you don't turn away the business, you know? Keep your ads positive. For me, I personally think that sold sign riders on a real estate sign are negative, because anybody that sees the sign out there and it says sold on it, they see it's not available anymore. You know, if you're going to have a sign on a property, just keep the sign there. People will call on it, and you could tell them, well, that property is no longer available, but I could see what else I could find for you in the neighborhood. You know, when it comes to family status, no limitation or preference on family size. You're allowed to say things like 2-bedroom, family room, or quiet neighborhood. Why would you, though? Because families usually aren't quiet. You should know that, right? A lot of yelling, screaming, and noise from the kids and having fun and playing and all that.
Yeah.
But anyway, you're allowed to say those things. You're not allowed to say things like married couples only, no more than 2 children, retirees dream home, or no young children. You know, this is discriminatory against the familial status requirement. So those testers I told you about, we're going to highlight that now here in the book on page 86. I'll show you a screenshot in a second. Testers for testing, those are those undercover mystery shoppers that they're trained by HUD, but they're not employees of HUD. And they could be the same sex or gender, sexual orientation, religion, color, or the opposite of you. That's why it works, because you never know with whom you're dealing with. Okay, they try to test you to see if you're treating everybody equally and fairly, or if you're going to take the bait and start discriminating. And I could give many examples where I was dealing with buyers on the phone and over the internet. Then all of a sudden, their emails are bouncing and their phone numbers don't work. Were they testers? I don't know. I had one girl who I was showing a property to, and I met her at the property. She got there before me, and I met her there. She already walked the backyard, and when I met her, she was like, I love the yard. I love the size. It's so big. It's beautiful the way it's set up. I was like, all right, let's get inside. I'll show you the inside. She loved the property. She loved it, loved it, loved it. Now, we get out, I lock it up, I'm putting the key back in the lockbox, and she's talking to me, and she's like, yeah, you know, my only concern here, I love this property. I definitely love the lot, the size of the lot. And the house is beautiful the way that he maintained it. But you know, I had to come off the parkway, and when I came off the parkway, I had to drive by some fried food places, and then I drove through a neighborhood that had way too many Black people in it. And this is this is a discriminatory thing, so I can't engage in that conversation. But now I'm leaning against the railing and I'm kind of like bouncing against the railing and I'm just like taking in what she's saying to me. In the meantime, I'm looking at this girl and she's black herself. And so I'm just like thinking to myself, she's got to be a tester. She's got to be a tester. This can't be real because like she's throwing out like every kind of racial stereotype against black people you could imagine. And I'm just like, looking at her. I got like a blind look that I'm just like staring into space, like right through her, It ended up, I thought she was a tester. She actually ended up being a legitimate buyer. She just didn't know how to describe what it was she was looking for. And she wanted something that she was accustomed to. And she was going through a lot of stress. Both of her parents just died in a car accident. And she became the instant mother, the instant carekeeper of her two younger twin sisters. So she couldn't afford the lifestyle that the incomes from both of her parents had, where they were previously living somewhere up in North Jersey in a fairly wealthy area. So she was trying to find something in an area that had a all concentration of all black people or white people. It was a mix, and she wanted an area that she'd feel comfortable in, but she didn't know how to describe what she was looking for. Not that I could chime in on that anyway, because I still can't search for homes based on who lives in an area. But as she's describing this to me, it just sounded so racist. But anyway, I ended up working with her and finding her a house, and she ended up being a real sweet girl. And I found them a house, and that was that. She was a real client. But the way that some people talk, like I say sometimes, can really throw you off sometimes. So, but I knew better than to chime in on that conversation. I was just like, nah. Ain't going there. So let's highlight this on page 86. Testers or checkers are undercover volunteers who want to see whether all customers and clients are being treated the same, because that's basically their goal. Okay. And that will pretty much conclude this chapter 4. So we'll do the key terms to review, and then we're going to break for lunch. Yeah, before we do the key terms to review. Okay, so that concludes this chapter. Let's do the key terms to review for chapter 4. So there's only one of them. Refusal to lend in certain areas, usually inner city. What do you call it when you don't give somebody a loan, even though they could afford to pay?
That would be
Think about the finances. What color ink do they use?
redlining.
The redlining. 4 is A. I'm sorry, 9 is A. Inducing panic selling based on prejudice. Inducing panic selling based on prejudice. We're going to use
Blockbusting?
Yep, we're going to bust up the block. 2 is B. We're peddling the panic, right? 2 is B. A federal law protected classes are race and color with no exception. There's no exceptions.
That would be the Civil Rights Act of 1866.
It would be, correct. 3 is C. A section of the Federal Civil Rights Act that covers housing. What's the section? There's a little key word there. Section of the Federal Civil Rights Act that covers housing.
Federal Fair Housing Act of 1968.
Well, that's what it's called, but what is the section of that Civil Rights Act? It's Title 8. If we go down to the bottom, 13 is D. Okay? 13 is D. Channeling home seekers to or away from certain areas.
Steering.
You're steering them. 11 is E. A statement about discrimination everyone listing property must receive.
Okay, I know this. Attorney General's
Yep.
memo.
Attorney General's memorandum about the New Jersey laws against discrimination as well as the federal laws. One is F. Court cases covering moderate income housing. Look, they don't even use the word low anymore, right? Pencil in there next to G, above moderate, right in there, low as well. So court cases covering low income housing.
Mount Laurel, 1
Yes.
and 2.
A 7 is G. A specific group that may not be discriminated against. What do we call them?
Protected class.
Yes, 8 is H. All right, next to letter I want you to cross out the word benign, because benign means it's harmless and there's nothing wrong with it. But all discrimination is wrong, so discrimination intended to correct past wrongs. What do we call that? Discrimination?
Law against discrimination.
A type of discrimination that's intended to correct past wrongs. So they give it a pass and they say, oh, it's okay.
Reverse discrimination.
That's reverse discrimination, correct. 10 is I. A federal agency enforcing civil rights compliance. What do we call that federal agency that enforces the federal anti-discriminatory laws?
Federal Fair Housing Act.
No, the agency. What do we call the agency? So sometimes it may help not to look at the answers and to try to just think of them before you look at them. Who enforces the federal anti-discriminatory laws?
HUD.
There you go. You got it. You see that? So sometimes that little trick works. See? So that would be 4 is J, the Department of Housing and Urban Development, or HUD for short. Undercover checker who monitors fair housing compliance. What do we call those?
Tester.
Yeah, check the testers. 12 is K. And New Jersey law governing discrimination in real estate transactions.
Federal Fair Housing Act.
New Jersey's law governing discrimination in real estate transactions.
Law against discrimination.
The LAD, correct. 6 is L. And federal laws setting many protected classes with some exceptions to it.
Federal Fair Housing.
That's the Federal Fair Housing Act, correct. So 5 is M. 5 is M. And that concludes chapter 4. So we're going to take our lunch break now. So let me first pause this. Okay. Chapter 5. What is real estate? So we're finally getting started in that. In this chapter, we're going to talk about the different characteristics of real estate, explaining what exactly it is, understanding what the difference between land and real estate is, and distinguishing between the characteristics of what's personal property and what is fixtures, because fixtures are part of the real estate. Okay, so now let's start off with this. When you own real property, what do you own? You get not only the land, but the bundle of rights that go with that land, describing what are the rights you have. The right of possession or season. This is your right to exclusively possess and own the property. The right to use the property in any legal manner. The right of quiet enjoyment, to enjoy the premises without being disturbed by others. The right of exclusion, that's the right to keep others from entering your property. That includes even when you rent property. When you rent property, what's happening? The owner of the land is temporarily transferring all their rights to a tenant for a limited period of time as defined in the lease, except for the right to sell the property. So the landlord, the owner of the property, is not allowed to enter the property either, because they transferred that right to a tenant. And we discussed some of that a little bit in the last chapter. And then the right to disposition or alienation. The right to disposition, that's to dispose of the property, to sell it, give it away. You could do it with it what you will. It is yours. Alienation, you're alienating yourself from the property. That means you're able to sell it. So alienation means transfer of property. And there's different kinds of alienation we're going to learn about. Voluntary alienation, involuntary alienation, alienation while you're alive, alienation after you die. So in simplest terms, the word alienation is a transfer of property. That term alienation will come up when we get to the mortgage chapters too, because we talk about alienation clauses in mortgages and loans. So that say that if you transfer the ownership of the property, the loan needs to be paid off in full. But we'll get off. So it's interesting. You need to understand the term alienation and that it means a transfer of property. So to be able to sell or give away the property, to lease it, the property, or transfer any rights to another. So alienation can occur while you're alive or after you die, and it can be voluntary. How do you alienate property voluntarily? Through selling the property, giving it away, devising it, that means leaving it in a will to somebody, leasing the property, licensing it, or dedicating it. Dedication is when you give land to the government for a public use, like streets, schools, and parks. Then we have involuntary alienation, which is, example could be foreclosure. They take the property away from you. It's involuntary. You don't want to give it up. You don't want to lose it, but you are. Escheat, that's when you die without a will deciding or specifying who's to get your property after you die. Well, if you did not prepare a will, then the government will take it. If no heirs can be located, then the government takes your property. Do you want the government to have your property after you die? You want the government to have anything after you die of yours? No. They get enough of my crap while I'm alive, right? So after I die, I want my family members or friends or whoever to get it. So you better have a will specifying who's to get your stuff when you die. Because if you don't, the only people that can make a claim to it are natural heirs. And beyond that, we're going to learn in one of these chapters who the natural heirs could be. And then we're going to also, if no natural heirs can be located, then the state will sell the property at auction and keep the money. We don't want that happening. Involuntary alienation could be partitioning. A partition is a court proceeding where one co-owner sues another, forcing them to divide or sell the property. Or a suit for adverse possession. This is when you got a squatter that's hanging out on your property and living there for a long enough period of time as defined by law. If they're using your land for a long enough period of time as defined by state law, they could take you to court and claim ownership of that land. All right, so within these rights are further rights to improve or devise. That's to leave by will. Mortgage, encumber, cultivate, explore, mine, build, lease, license, dedicate, give away, abandon, share, trade, or exchange the property. All right, so let's get into it. So let's highlight the bundle of rights story here. Real property ownership is often described as the bundle of rights. Can you limit somebody's rights when you sell your property on how they can use your property in the future? Sure you can, as long as it's within legal right, as long as it's within the framework of the law. You could say what and how people can use your property. I think I gave the example once before that sometimes a gas station could be sold and the seller can say the property can never be used as a gas station again. All right. And if you agree to those terms, well, then there's nothing wrong with it. There's nothing illegal about that. But then if you later on violate those terms that you agreed to, and the person who sold it to you finds out about it, they could take you to court and require you to hand the property back over to them because you violated the terms that you agreed to in the sale. Okay. So if you buy a property and it says that you can't use it as a gas station, when you sell that property now to someone else, what are they getting? They're getting the property and all the rights that you possessed. You can't create any new rights for them. You can only pass along the ones that you have. And your rights are already limited. They say that you can't use the property as a gas station. So now if you sell that property to someone else, they can't use it as a gas station either. They inherit your rights. It runs with the land, that limitation. So that's the way that it works. All right. And so let's also highlight devise means to leave by will. And let's right there, page 374 as a cross-reference. That's where we'll go over that term devise further. Now here's some other terminology. So we're going to go over some of these death terms. They're not all death terms, but most of them deal with death. What is an heir? An heir is a natural blood relative who can inherit belongings of the relative who died. Devise is a transfer means to transfer or leave property by will upon death. You could devise, you could name somebody in a will of who's going to get your property. You know, your last will and testament. The devisor is what you call the person who's giving you that property, leaving it to you in a will, and the devisee is the one who's receiving it. Demise is not to be confused with devise. Devise means to leave property in a will to your heirs or whoever you want. But demise is often confused with devise. This is why I'm putting this term in there. It is not a death term, even though it sounds like it. Haha, you finally met your demise. No, demise is a transfer of property by lease. Every lease has a demising clause in it that states, you know, who's going to get your property and what they could use it for. So don't confuse demise with devise. There's only one letter difference in there, and often people mix the two up. Do not. Devise is the death term, and demise is a transfer of property by lease. Then we have testate. Testate is all it does, it just means that you prepared a will. Intestate means you did not. These are Latin terms. Words that usually begin with in mean not. You know, they begin with the prefix of in, which means not. It's not testate. You did not prepare a will. So testate means you prepared a will. Intestate means you died without a will. Now, a man who makes a will is called a testator. A female who makes a will is a testatrix. Probate is a court proceeding that determines who the natural heirs are and to confirm who the devisees of an estate are. Because you could leave your property to anyone in your will. They don't need to be family members. They can be friends or charities or whoever you want. So probate will determine who any natural heirs are if you died without a will. So they know who can make a claim or has rights to your property. Or they also confirm the devisees that you may have named in a will to receive your stuff. And no matter if you had a will or not, before your assets can be distributed to anyone, the courts have to make sure that all your debts have been paid. So probate is the process primarily to make sure that all of your debts have been paid before your assets are distributed to any heirs or devisees. Mainly, they want to make sure you paid your taxes. Because two things are certain in life. Death, you're all going to die, and taxes. You all got to pay taxes. Even after you die, you got to pay your taxes. They do it through probate is the way they make sure of that. They'll get you one way or another, right? They get you coming, they get you going.
There you go.
Get you on the way out.
Through that.
Now, an executor is somebody who you name in a will. Here, let's start it. Let's do it this way. An executor is a man. An executrix is a female that you name in a will. It's somebody that you trust, that you name in a will, to put them in charge of disposing of your assets and distributing your assets according to your final wishes. So you want to make sure that's really someone that you trust, right? To make sure that they're going to be making sure that your final wishes are carried out the way you wanted them to be carried out. So an executor is a man, and executrix is a woman that you name in a will to make sure that your final wishes are carried out according to your will. Now, if you made a will, but you didn't name somebody to be an executor or an executrix, the court will appoint somebody to do that for you. And it's usually a lawyer. And that person is called an administrator. So an administrator is somebody who's named by the court to make sure your assets are distributed according to your will. The executor and executrix is somebody that you specified and named in the will to do that. And remember, these people that you name in a will are entitled for that job task that they take on. They're entitled to 10% of your assets for doing this. Not expected they do it for free. Now, descent and distribution. Every state has their own laws of descent and distribution that dictate who your natural heirs are in the event that you do die without having made a will. Who can claim your stuff? Who has the legal rights to get your stuff? Do you wonder? You want to go over it? Are you curious who has the legal rights to claim your stuff and get your stuff?
Maybe a family.
We're going to find out about that in a moment. Escheats is when you die intestate without a will, and no heirs can be located. Heirs are your natural blood relatives. The property reverts to the state. So the state will sell your property at auction, and then they'll hold those funds in a fund for 1 year, in which time your heirs can step forward and claim it. But if they don't, the state gets to keep it after that. So all that stuff is in chapter 20 later on, but guess what? We're going to do a little diversion and go to chapter 20, and we're going to learn all about that stuff too. So what we'll probably do is we'll finish this chapter first. We'll do chapter 5, and then we're going to go to chapter 20 because it's kind of short, and then we'll come back to chapter 6. That's the order that we'll do it. So a legacy or bequest. A legacy is your personal property that you've amassed over your lifetime that you have to leave to somebody. Your legacy is what you leave to your children, for instance, or whoever you leave your estate to. That's your legacy is your personal assets. The bequests are your wishes. I bequeath to thee my vast fortune of $4 in my bank accounts. Okay, so the bequest is your wishes of who you wish to get it, and the legacy is what you're giving. Now, dower and courtesy are specific rights to New Jersey. They're ancient rights. New Jersey abolished the creation of any new or dower courtesy rights in May 28, 1980. But what are dower and courtesy rights? Well, dower is an ancient right in which the wife has interest in her husband's estate, in all the property that her husband owned during his lifetime while they were married. But he died. So she has the right to claim it. So she has a right to interest in that. And courtesy is a similar right that the husband has in all the property that the wife owned during her lifetime that he has a right of interest that he could claim. Now, can your husband or wife leave some property to someone else, like their mistress, perhaps?
Or not.
They can. They can. The person does not have to leave you all of their property, but the law does specify they have to leave a certain amount of it to their spouse if they're married. So this is an interesting little thing. What happens to your stuff when you die? You're still married, you know. If you want to really dictate it, you have a will. So dower is that right that the wife has in certain interest in her husband's property upon his death, and courtesy is a similar right that the husband has in the wife's property upon her death. And New Jersey abolished the creation of any new dower or courtesy rights on May 28, 1980. All right, so which is the wife's right?
Dower.
And the husband's is courtesy.
It's the courtesy.
And what year did New Jersey abolish the creation of any new dower or courtesy rights? You need to know this for exam.
1980.
1980?
You need to know May 28th, 1980.
Oh, the whole thing? Okay.
You need to know the whole thing. All right. Now, if anybody in New Jersey was married before May 28th, 1980, they still to this day have dower and courtesy rights. New Jersey did not abolish dower and courtesy rights. They abolished the creation of any new ones. So anybody who was married before this date, May 28, 1980, still has dower and courtesy rights with their spouse. So that's why it's important for us to know this. Because if we have a married couple that comes to us and they want to sell a property, but yet only one of them is listed as the owner of the property, do they both need to sign contracts, or only one of them that's listed as the owner? Well, when were you married? If you were married before May 28, 1980, your spouse has an interest in the property, so you both need to sign, even if only one is listed as the owner.
Wait, can you say that again?
Sure.
Yeah, please.
If you were married before May 28, 1980, both spouses need to sign contracts, even if only one is listed as the owner.
Okay.
If you're married after May 28, 1980, and you're married, only the one that's listed as the owner needs to sign the documents to sell the property. So how do I remember? Because you need to remember which one is the wife's right, which one's the husband's right. How do you remember what dower and courtesy rights are? Well, I'm going to show you an easy way to remember. And I like to do it by singing. Are you ready to hear? Me, 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 me. Okay, here we do. Dower begins with a doe. And a doe is a deer, a female deer. So that's how I remember that dower is the wife's right. She's the female. Dower begins with a doe, and a doe is a deer, a female deer. I know it's spelled differently, D-O-E, but that's the way I remember it. It helps me remember. And courtesy, because men should be courteous to women, is the way I remember that that's the husband's right. Okay, so that's a little trick that I do to remember which one's the wife's right, which one's the husband's right. And as far as the date goes, no tricks to that. You just need to memorize it. May 28, 1980. That's the year that New Jersey abolished the creation of any new dower or courtesy rights. So people who are married after May 28, 1980, your spouse has a marital interest in only the primary marital residence. All the other properties that you may own, your spouse has no interest in. You could leave them to whoever you want. But they get the primary marital residence upon your death. Now, there's a couple websites I got here. Missingmoney.com. New Jersey no longer participates in it, but other states do, and New Jersey used to. So missingmoney.com is run by the government. It's free website. They'll never ask you for a credit card. If they do, you're on the wrong website. Where you could search your name or family members' names from other states, because New Jersey pulled out of it, no longer puts information in that database. Instead, now they decided to create their own type of missing money website that's called unclaimedproperty.nj.gov.
I just actually filed a claim on that website for unclaimed monies that I had. That's so funny.
Look at that. So this class teaches people, because we always get at least one person in a class that finds money that's owed to them.
Yep.
So missingmoney.com is deals with other states. New Jersey no longer participates in that. But as far as for New Jersey, you could go to unclaimedproperty.nj.gov. They created their own missingmoney.com website now, type website, where you could find money that's owed to you. Now, different things stay in this database for different amounts of time. If it's a property, somebody died and you had a right to it, it'll be in there for 1 year. If it's bank accounts or saving CDs or other things like that, it depends on banking regulations. Sometimes it's 7 years, sometimes it's 6, sometimes it's 10 years. It depends on what it's for, that it would stay in that database for a period of time. What did you find? Old paycheck or a bank thing, or?
It was from a bank. Yeah.
Okay.
Oh, wow. Okay.
Yeah. So that would be in there for a longer period of time. Those bank accounts, maybe you forgot about it, or you forgot to close it, or it was inactive, and they submitted the money to the state. Yeah. I had this happen to me one time where I got a letter in the mail, and it came from PricewaterhouseCoopers, the accounting firm, and they said, "Hey, Google owes you money, and you didn't give them a way to pay you. So if you don't contact us by this date, we're going to turn it over to the state, and you're going to have to go through the state to get it." And I was like, "Google? What the hell is Google owe me money for?" I was like, "This can't be right." And I was like, "Oh, I know what this is for." And I remember that, I'm a techie guy and I go through some stuff, it has to deal with online things. And Google owns YouTube. Google has their own monetization. Oh, Google's listening to me now. Stop. Because I said their name, they start listening. I said the G word, and they started listening to me and spying on my phone. So they had this monetization app because they sell advertisements to people who are content creators. They allow them to market other advertisements on their content, and then they can make money on it. So basically, I made a YouTube video years ago. It was like a stupid video. I don't even know why I recorded it. I seen somebody else with a video like this, so I made my own version to see if I could do it, and I recorded it just to post it on YouTube as a first video. So I created a video that was how to fold a T-shirt in 2 seconds or 3 seconds or something stupid like that. And so I was at my office. It was at the end of the day. It was nighttime already. I'm all like in an old wrinkled shirt, and I'm like, you can see I'm dead from the day. And I put this T-shirt on the table, and I go boop 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 boop. There you go. Look, even I can do it. And so I had a short video like that, and I posted it on YouTube. And then I went to Google's monetization app, and I created a profile there, and I linked the two. And so now you can make money for every time people watch the video, ads come up on it, or you can have roll-in video ads before and after, and ads come up during it and stuff, the little banners. So I created this like 2 years prior, and I totally forgot about it. And then PricewaterhouseCoopers said, "Well, Google owes you money." And I was like, "Oh, okay, I know what that's about. Just curious to see how much it is." I went over there, I filed, I set it up. I went online, I seen how much they owed me. I was like, "Holy sugar." And then I went in there and I linked it to my bank account so that they could transfer the fund no. I had them send me a check. I put my address in there so that they could send me a check. And then they sent it to me. And I was like, holy crap, it was over 10 grand.
Wow.
Yeah, I made
yeah.
one video, forgot about it for 2 years, but apparently it had so many views that the traffic for the ads that were sold on it, Google paid me over 10 grand for it.
I love it.
Now, they don't make it so easy to monetize content like that anymore. Now they require you to have so many thousands of unique followers and visitors and so many videos with daily views and all that. They make it harder for you to make money. This way they keep more of it in their pocket now. But see, that's some passive income for you guys too, by the way. You can do things like that. Anyway, unclaimedmoney.com, unclaimedproperty.nj.gov is another website that you guys can check out. So what we're going to do is we'll go to chapter 20 later after we finish chapter 5 here, and then we're going to go over all these death terms and stuff. We'll learn about them in a little more detail, and we're going to find out about who inherits your stuff through the descent and distribution laws of New Jersey if you die and you don't have a will. Does everybody here have a will or no?
Nope.
No? You got kids?
Yes.
You guys should have a will. You
Yeah.
know,
You're right.
You know, whether you're married or you have kids, you should have a will. Because if you don't, I mean, they're still entitled to be the heirs to claim your assets. However, now it has to go through probate first. It has to go through the court. They have to verify who you are and that you have a legal right to it. And it could be a long, drawn out process to something that could be done like this. Instead, it has to be a long, drawn out process. When your kids could have gotten whatever you wanted to leave to them a lot easier. And now, especially if there's no other adults involved and it's only kids, now somebody's going to have to get paid to make sure that they're the rightful heirs and make sure the assets get distributed it's like a whole bunch of additional nonsense. And it also eats into the value of what it is that you're leaving them, the money that you're leaving them. So you should have a will. And New Jersey, in chapter 20, we'll go over what the process is for making a will. But I'll tell you one thing. What you could do right now is you could grab a piece of paper and just put on there, this is my last will and testament, just to have something right away in case you get hit by a bus walking out the front door. You could write down your name, your social security number, your address, all that stuff, and write down, this is my last will and testament, who you are, and all that stuff. Put the date on there and say, label all your assets and who you want to get all your stuff, and then sign it. If you handwrite the entire thing, that's called a holographic will, and no witnesses are required for that. Just your handwriting and your signature, okay, and date it. That's it. And then this way you're at least covered until you get a formal will written up, And you could either go to an attorney to get it done for a couple $100, or you could buy Quicken Will Maker or one of those softwares that make will that's legal in all 50 states. And you could answer the questions and it'll print out a will for you. But those require 2 witnesses because it's a printed out will. It's not handwritten. They require 2 witnesses. However, somebody who you name in a will to be a beneficiary, they can serve as a witness on your will as well. Okay, and make sure if you make a will that it's someplace where people can locate it. Don't put it in a safe that nobody's got a combo to. It has to be someplace where it can be located to. All right. Land. What is land? Land refers to the surface of the earth, including the water and anything permanently attached to it by nature. It includes everything extending downward from the surface to the center of the earth and everything up to infinity and beyond. And this includes the subsurface rights, air rights, and water rights. Now, the term parcel refers to a specific tract of land that's been measured out and has legally defined boundaries to it. That's all the word parcel is. So sometimes we may use the term parcel. I just want you to know what the term parcel means. You know, it's basically a piece of land that a surveyor drew out the boundaries on and they measured it, you know? Now, real estate, the definition of real estate is the same definition of land, plus all man-made improvements. So what's a man-made improvement? An improvement includes both buildings erected on the land as well as the streets, utilities, sewers, and other manufactured additions to the property. Okay. That is the definition of land or real estate. So land, therefore, may be, let's highlight this on page 94 and 95. This part's on 95, this part's on 94. Therefore, land may be defined as the earth extending downward from the surface to the center of the earth, everything up to infinity, and all things permanently attached to it by nature. The term real estate includes land as previously defined, also man-made improvements, and the word improvement includes both buildings erected on the land, streets, utilities, sewers, and other manufactured additions to the properties. And the concept of real estate could also include all the legal rights to the property, and we call them the bundle of rights, right? So sometimes when you buy property, it can be restricted in some way, shape, or form. Like you can't use it as a gas station, you know, as one example. So let's just do those highlights, write those notes. Let me turn the slide, and I'll give you one more slide with those definitions both on the same slide. Okay, so here we go again. The term land and real estate are often used interchangeably to describe the same thing, although they do have differences in their meanings. Land is the surface of the earth, including the water and anything permanently attached to it by nature, which does not require annual cultivation, like grass, trees, and bushes. You don't have to plant them every year and they come back on their own. So therefore, they're considered to be part of the real estate. And everything below the surface to the center of the earth, and everything above it to infinity, and all the rights, interest, and benefits that go with it. In other words, the bundle of rights. So real estate, however, is the same definition as land, plus man-made improvements and the bundle of rights. All those rights, interest, and benefits that go with it. So the definition of land is the surface of the earth, everything above it to infinity, everything below the surface to the center of the earth, and everything that's on it through nature that you don't have to plant, like trees and bushes and grass. It's there automatically every year, comes back on its own. That's part of the real estate. See, flowers and crops that you need to plant every year in order for them to be growing because they die every winter. Those things can be considered personal property. So when somebody sells the land, they could technically take it with them. Their flowers and such. If it's a farm, the crops. So you will get a question on exams about knowing the difference between land and real estate. This is why I stressed that bit, spent a little time on that. Now, you guys ever hear the word tangible before? Tangible or intangible? Something is tangible means that you could touch it. If it's intangible, you can't touch it. So another word for tangible is corporeal. So a corporeal asset is another word for tangible. It's something you could touch, like buildings and trees. An incorporeal asset is another word for intangible, and it's something that you cannot touch, yet it does have value to it, like a beautiful mountain view or ocean view. Even though you can't touch a view, it does add value to the property, right? It is an intangible asset or an incorporeal asset. What about your rights? Do you value your rights?
Yes.
Well, can you touch a right? You can't touch a right, right? But you do value them. It's something that you can't touch. It's an intangible asset that you cannot touch, is your rights. Now, an example of rights we have here is a lease. A lease is considered to be personal property that is an intangible asset. Why is it personal property and it's not real estate? Because you don't own it. A lease is where you're occupying someone else's property for a limited period of time as defined in the document we call a lease. So a lease is just a piece of paper that explains what your rights are. And you can't touch a right. So therefore it's an intangible asset. And you don't own the real estate. So if you don't own it, what kind of asset is it? It's either real or personal. If you don't own the real estate, it's personal property. Boom. That's how we came to that conclusion. So although you can't touch the paper, although you can touch the paper that the lease is printed on, the lease signifies the rights. Okay, so I basically spell out everything I just explained there. Boom, boom, boom. So you need to understand that concept because this is often a question on exam too. You know, a lease is considered to be personal property that's an intangible asset. And you need to know the term corporeal means tangible and incorporeal means intangible. Okay. So, real estate is then defined as the Earth's surface. Okay, here's the definition again here in the book. If you want to highlight it on page 95 for real estate. Real estate is then defined as the Earth's surface extending downward to the center of the Earth and upward into space, including all things permanently attached to it by nature or by people, and all the rights and benefits in it. Then we'll also highlight corporeal means tangible. Incorporeal is intangible, like views or rights. And then right beneath that, a lease is personal property and an incorporeal or intangible asset. Let me know when you got that.
Okay, I'm good.
Okay.
I'm good as well.
All righty. Rights to property are not ownership of it. These rights may be owned or leased independently of the land itself, like the air rights, the water rights, or mineral rights or subsurface rights. Subsurface, often also referred to as mineral rights, refers to the minerals that are in the ground or beneath the surface of the earth. So that's a right to the natural resources in the ground, as well as simply the space below the surface of the earth, depending where we're talking. If we're talking like in an urban area, a city, the space below the ground could be valuable to you because we in a city there's only so much land. You got to build up or you got to build down. So there's value to both. Mineral rights could also be oil, gas, gold, silver, other precious metals or minerals that are in the ground. So you could sell the rights to them and still be the owner of the land. So therefore, somebody else can have a rights in your property that you own. For instance, I had a girl in one of my classes that she moved here from Texas. And apparently it's a common thing in Texas that when you sell your property, you keep the mineral rights to it. And you write into that contract that you have the right to be on that land to extract those minerals from it. So this way she sold her land in Texas. She remained the right, she kept the mineral rights, the subsurface rights, and she hired an oil exploration company to drill for oil on the land, and they found some. Now she's not independently wealthy or anything now, she said, but she gets a check every month that's enough to pay her and her mom's mortgage here in New Jersey. Not bad for property you don't own anymore, huh?
Nope.
So can rights have value to them?
Yep.
Yeah. Especially air rights. Look at air rights in New York.
Oh, yeah.
A place like New York, you got to build up. Air rights in New York can be worth upwards of 3/4 of the value of the land itself. Subsurface rights are dealing with the mineral rights and the space below, like the oil and gas or coal. Rights to the property are not ownership of it. Now, because you have air rights above a property, does that mean that you could prevent an airplane from flying over your property? No. The FAA, the Federal Aviation Agency, has exclusive jurisdiction of everything above 500 feet above the highest point of your property. So even though you own everything above your property to infinity, the air rights, the FAA has jurisdiction that they could use the space over 500 feet over the highest point. Now, air rights can be very valuable, especially in places like New York City. Look, they give this example here. That if you take a look at that former Pan American building, Pan Am used to be the largest airline in the world. It's now called the MetLife building in New York City. That's where you got Grand Central Station underneath it. It was built that way for a particular reason. That airline built that tall building there with a helipad on the roof so that people could come into Grand Central Station, then take the elevator up to the roof, hop on a helicopter and go fly out to an airport. Or they could fly in from an airport to New York City, land on the roof, take the elevator down to the basement and get on a subway or a train to go wherever they need to, or go out to the street and call a taxi. And the helicopter, those helicopter shuttles were pretty cheap to fly in. Now, some things that people weren't counting on and they didn't think about too much was the noise from the rotor blades of a helicopter coming into the city. That created a little bit of a disturbance. And another thing they didn't really think about is what if there's an accident? So the interesting thing with this is, though, you have one owner of the land that has these storefronts there at the land level. The city, the Port Authority, owns the subsurface rights where they have the subway and the train station. And Pan Am at the time, now MetLife, owned small sections of the land itself where they built the foundational supports for the building, because buildings don't float in the air. So they had to buy and own small portions of the land that they built the foundational supports that that building is sitting on, as well as they go into the earth too. So they had to have the subsurface rights for those as well. And then they constructed the building. So in that one little limited space, you have one owner of the rights to the area underneath the land. You have the landowner that has this, but they sold the air rights to the building owner, as well as small foundational support sections of the land. So here's that MetLife building as an example. Now, this is a historic thing, the Grand Central Station. Now, it's not, the MetLife building isn't sitting right above the entire Grand Central Station, but Grand Central Station goes pretty deep far back. And here's the escalator that goes from the Grand Central Station up into the MetLife building. You see the building's a little bit set back there. There's storefronts at the street level. Here's the mock-up of the building when they were going to create it. Here you can see the Grand Central Station, but the Grand Central Station goes all the way back here too. And the MetLife building is built above that. You see, here's before that building was there. You see the Grand Central Station, how far back it goes? And here's where they were constructing the foundational supports for that building, that MetLife building. And you can see the escalators down there. And here's an example where it was the Pan Am building and their logo, Pan Am. And here's the helicopter landing on the roof and the helipad. And they did away with that because one day there was an accident. A helicopter crashed on the roof. The landing, it actually didn't crash. When it went to land, the landing gear broke and the helicopter tilted on its side. The rotor blades went flying off the roof and then came back into the building on one of the floors. But one of the very large wheels of the helicopter fell all the way down, all these stories down to the street level. And it's amazing, only one person died. Well, actually, I should say two. It was a pregnant lady. The landing gear landed on a pregnant lady on the roof, rather on the floor, on the ground, the street. And on the roof, I think there were several passengers and people that were on the roof that died as well. So here are pictures of that helicopter crash. See this landing gear, how it's attached to it? Well, I guess it gets stress cracks after so many landings and taking off, and it cracked and it flipped, and there was that unfortunate accident. Then nobody thought about these possibilities. These helicopters could crash and what would happen to the street below. So since then, air flight has been restricted above New York City, way before any terrorist attacks, because of this, except for emergency circumstances for hospitals and helicopters for the hospital. So there we go. That happened on May 16th, 1977. Prior to that, you could have air travel there in New York City. Think about this for a second. How do you build something like this above a city street? Can you just build something above a city street? Above someone's property that's not yours? How did they build this? You got two buildings here that have a connection between them. I want you guys to think outside the box a little bit. Try to brainstorm. How would something like that get built? Well, maybe they bought the air rights from the city to build above the street. Or maybe the building owner who owns this building and this building also owned the land below, and then they dedicated that land to the city, but they kept the air rights. So they were able to build this. See, now we're starting to think that you don't just have to own the land or the real estate. You could have air rights and subsurface rights, and it's more than just you either own it or you don't.
Hmm.
Now let's talk about property rights. Let's talk about the water rights, rather. Water rights are more complicated, and we're going to be learning some sciencey terms now. I'm going to apologize to you in advance because don't shoot the messenger. I'm just here to teach it to you. I know you didn't take a real estate class to learn about science, but like it or not, here we go. We got to learn about water rights. Now, when we talk about water rights, we could be talking about the right to use the water, but that's not what we're talking about here. Usually when we're talking about real estate, when we speak of water rights, we're talking about what exactly do you own when you own land that borders water or that has water sitting on it or running across it. What exactly do you own? Does it affect your ownership? And what type of property ownership do you have? So on page 96, where it says water rights, I want you to highlight this sentence or these two sentences. Land bordering on oceans, seas, or large lakes affected by tide currents are known as littoral. Land bordering or traversed by a stream or waterway is known as riparian.
Okay.
All right. So what does that mean? Littoral begins with an L. Think of lakes and large bodies of water that are affected by the tides. You got high tide, you got low tide. That's like the ocean, right? You go to the beach, you got high tide, low tide, right?
Yep.
Those are lakes and large bodies of water. Large lakes and large bodies of water. You know, like the Great Lakes, they got their high tide, low tide, right? The key to knowing it's not just high tide or low tide, but they are navigable waters. That's the key to determining if you have littoral property rights or not. If you own land that is bordering water that is affected by the tides, and most importantly, has commercial shipping through it. So basically, it has it's navigable waters. That's what navigable waters are. It means commercial shipping. We're talking about like the super freighters and tankers and cruise ships. We're not talking about a little fishing boat or you know, weekend boat.
Gotcha.
So I just first want you to understand the difference in how to identify if you have littoral property rights or riparian. So you have littoral property rights if you own land that borders water that's affected by the tides, that has high tide and low tide, but most importantly, the most important factor there, it is navigable waters. So commercial shipping goes through.
Okay.
You have riparian property rights if you're thinking of you have water, you have a little pond on your property, or you have a little stream or babbling brook running through it. There's no commercial shipping. It's not controlled by the tides, the water levels. All right. So but most importantly, there's no commercial shipping going through it. Then you have riparian property rights. So now that we can identify the difference between littoral property rights and riparian property rights, what's the difference? Well, riparian rights, if you have riparian rights, an owner can actually own the land which the water is sitting on or running across. You actually own the land under the water. Littoral rights, the land is owned only up to the mean high water mark of those navigable waters that are controlled by the tides. That's the difference. So you see, on the left, we have riparian rights or non-navigable stream. You could actually, if two properties are separated by a stream, the property line becomes the center of the stream. So now each property owner owns the land under the water up to the center of the stream. If you have littoral property rights, you only own up to the edge of the water at the high tide mark. You ever see the stain in the sand when the tide goes out? You can see the stain in the sand where the water went up to.
Yep.
Okay.
Yeah.
That's the high tide mark. Okay.
Okay.
That's the mean high water mark. The mean is the average when you don't take into consideration like abnormal storms where the sea levels rose temporarily. Okay. The mean is the average high water mark. So the property owners only own up to the mean high water mark.
Okay.
You don't own the land under the water in the ocean. So here's a slide I put together. You may want to snap a picture of this one that gives you the definition of all the water rights words and terms that you need to know that we're going to go over right now.
Okie dokie.
Okie dokie, schmokey. All right, so littoral, you have littoral property rights when you own land that is bordering navigable waters that are controlled by the tides, meaning commercial shipping can go through them. So the landowner only owns the land up to the mean high water mark. You have riparian property rights if your land has rivers and streams that are non-navigable, bordering or running across your land. The property owner actually owns the land under the water. You could have a pond on your property, on the property. Listen to the words, on your property. You know, so you own the land underneath that water. That's the difference. Now let's get into those science-y words, those scientific water words. Avulsion is the sudden change of a course of a stream.
Okay.
Avulsion has a letter S in it for sudden change, I guess, of a course of a stream. Think of it that way. Erosion is a word that we all know. You know, you could have erosion by rust. You know, metal erodes from rust, right? Water and wind can erode our beaches by wearing away the sand on the beaches, right? It pulls it out into the ocean. So the wind blows it away. That's erosion, is the wearing away of land by the wind or water.
Okay. Hey.
So if land can be worn away by wind or water, is it possible that wind and water can also deposit land somewhere and give you more land? Yes.
Really?
The term is called accretion.
Oh.
Accretion is the opposite of erosion. It's the process where the water deposits additional solid material like sand, dirt, rock on your property. Sometimes it can be a positive thing, sometimes not so much. I'll show you pictures where it's not so much positive, but so accretion is the process, is what we call the process of the water depositing solid material on your property. That solid material that was deposited by the water is known as alluvium. Look at the word avulsion and the word alluvium for a second. They both got A's, L's, U, V's, I's, O, N's in them. Avulsion has an S in it for sudden change of a course of a stream, so I remember that that's what that means. How do you remember what alluvium is? Well, alluvium, avulsion, they both have L's, but alluvium has two L's in the word. The one where you have two L's is where you gain some dirt. You gain an L, you gain some dirt. So alluvium is the dirt that you gain. Accretion is the process of the water depositing the dirt. Alluvium, it has two L's. You gain an L, you gain some dirt. I even have it written that way. Yeah, like that's a real word. You gain some dirt. Alluvian has two L's, gain and L. You gain some dirt. And if you were to listen to all the environmentalists out there with their trust the science, except for the science that we don't agree with, if you believe those people and you follow them all the time, they'll have you believe that the sea levels, the polar ice caps are melting and the sea levels are rising. We're all going to be underwater and the Earth is going to end in 10 years. They say this every 10 years. Or they come up with a new conspiracy like that every 10 years that never comes to fruition. The fact of it is polar ice caps melt, but then they also refreeze. You know, sure, we're not getting glaciers back, but we have plenty of ice up there, and it's not all melting. We're not losing the Arctic or the Antarctic. And the truth of the matter is, the Earth is not round. Oh my God, I said it out loud. He's one of them conspiracy guys. No, I'm not. The Earth is egg-shaped because the Earth is also spinning. So the Earth is fatter in the center like an egg and taller. It stretches out. And if you don't believe me, you could just YouTube it and start looking up why airline pilots set navigational routes instead of having just going from point A to point B, which you would figure is the shortest distance, right? Sometimes if you look at the routes that they have, they look like they're going way out of their way to get to another destination. Well, that's because the shape of the Earth and how many miles you actually have to go. The point A to point B in the straight line on a flat map may be looking one way, but if you were to look at it, how round it is, it's shorter to go a longer path. It's what seems like and looks like a longer path. But either way, the Earth is not, it's not round, but it's also not flat. I'm not one of them flat earthers either. We have mountains and we have valleys, right? So some places the sea levels can be rising. Other places, they're falling. Don't believe me? Do you know that the meadowlands used to all be underwater?
Oh, yeah.
The sea level went out, the tide went out, and it never came back. Oh my God, the conspiracy theorist. Yes, it's not a conspiracy because today we've got the parkway, we got the turnpike, we got stadiums, we got shopping centers there. That's not man-made. It wasn't built up by man. The sea levels naturally went down and they never came back. If you got any kids that are in the Boy Scouts and you ever go on a trip over there, they actually do tours of that swampland over there on canoe. I had one guy ever in my classes know about this. I asked him, you know what the word reliction is? And the guy was like, oh yeah, it's when the sea levels go out, tide goes out and never comes back. And I was like, how the hell do you know that? I was like, I didn't even know that until I started teaching these classes. How did you know that? He's like, oh, just the other day, I was on a trip with my son at the. He's in the Boy Scouts, and we went on a canoe trip, a guided tour of that swampland over there, and the tour guide was telling us, well, this was all once underwater, and through the process of reliction, that's when the sea levels go out and they never come back. And I was like, you're the only guy I've ever had in this class that knew that. I didn't even know that until I started teaching it. So, reliction, that's what reliction is. It's a permanent receding of the tides. Receding, the water pulls out from the land, it recedes away from the land, and it never comes back. Now, never, I guess, is a long time, but let's just say in our lifetimes. Yeah, it pulled out and it never came back. So this is not creating new land. It's just exposing the land that was underwater that was always there. So reliction is not the opposite of erosion. Avulsion is. I'm sorry, accretion is. So reliction is not the opposite of erosion, which is the wearing away of land. Accretion is the opposite of erosion because it's depositing solid material, building up, making new land. Whereas reliction is not creating any new land. It's just making it dry. It's creating new dry land because the water went out and never came back, but that land was always there to begin with.
Okay.
If you have a pond and that pond dries up on your property, you have dry land that you could use, additional land you could use that previously was covered with water. That land was always there. It was just covered, right?
Mm-hmm.
All right, so these are the science terms for the water rights that you need to know for exams, and you will get them on both exams. I'm sorry, but you should probably take a picture of this slide. You need to study it. Littoral, riparian, avulsion, accretion, alluvian, reliction. You need to know all these terms.
Oh boy.
I know. And how many people actually do real estate around water is minimal. But that's why we need to know these terms.
Okay. Okay.
All right. So let's do some highlighting now of those things that I just explained on that custom slide I made. Do all the highlights. Let me know when you got the highlights and the little notes taken here. By the way, there's some interesting factoids here too. New Jersey contains approximately 124 miles of coastline. About half of that is owned by municipalities. A quarter is owned by private ownership. And the state and federal governments each own about 14 miles. Property that borders on water is measured by front footage, lakefront property, waterfront property. Remember, I told you guys frontage is the width of the front of the properties of the lot, right? However, when you have water property that's touching water, the more valuable side is touching the water, right? You want lakefront property or beachfront property. That's more valuable, right? You get to look at the beautiful ocean. So frontage is actually measured on the side that the water's on. How much front feet are touching the water? That's your frontage for waterfront property, beachfront property, lakefront property. Make sure that you cross out these words here, creation of dry land by the, because reliction is not creating any new dry land. It was always there. If you need me to read the words that I have here because you can't understand my chicken scratch, I'll tell you what it says. Just let me know.
All right, I got it whenever you are ready.
Got it, Yvonne?
2 minutes. Not even.
Okay.
Okay.
So you got the notes and everything? You got it all?
Yep. Let me just snap this just to make sure because I think
Okay. Okay.
I'm in the middle of your chicken scratch.
It says exposing land, not creating it.
Okay.
A permanent receding of the tides or water evaporating / drying up.
All right. Gotcha. Let's rock and roll. Let's hit it and quit it.
All right. So littoral rights, you only own the land up to the mean high water mark. The rest of the underneath the water is owned by the public. Once again, here's that definition sheet again. There are all the different words. If you have navigable rivers, you only own the land up to the mean high water mark. The rest is publicly owned. However, if you have a river or stream that's non-navigable, both property owners own up to the center of the stream. But if that stream were to change its course through the process of avulsion, the property line would not change. It would remain where it had always been. So here's an example. Say that the property line was always here. This is where the stream is running. Then all of a sudden, the water running over here for years and years and years, it uncovers a rock. So now that creates a little stream starting to push the water in another direction. And then all of a sudden, it breaks off and starts running this way. The property line doesn't move. It would remain where it always had been. Here's an example in Tom's River of putting up a little beach erosion fencing before the seasons where we get the storms coming in, so that it could try to prevent the water from pulling all that sand out that they got to replenish every now and then. Here's an example of accretion. Through the process of accretion, the water deposits additional soil. In this case, it's sand. That's the solid material. Not exactly positive in these examples here when they're getting additional land, right? It's actually more destructive.
Yeah. Oh,
How about eminent domain? You guys ever hear that term, eminent domain, before?
I have.
Eminent
No.
domain is the right of the government, even though you own land. Eminent domain is the right that the government has to take your land from you if it's needed for the greater public good. But they can't just take it from you. They have to justly compensate you for it, whatever its current fair market value is. You ever watch this show, Ozark, on Netflix?
Oh, the best.
Oh, I have to see that. No.
This is a scene from Ozark on Netflix where they talk about water rights and eminent domain. Now, all these people are gangsters and drug dealers or cartel members, or they work for them. So it's interesting. They're all bad people here. So it's interesting, though, how they show how one group uses the law on their side to take another guy's land using eminent domain. Do you need to have, let me ask you a question. Can I, Victor Kaminsky, take your land, your property from you using the power of eminent domain?
No.
Personally, I can't, but I can use eminent domain to take your property. You know how? All I got to do is know who has the rights to eminent domain to take your land. And then I'll go cozy up with them and tell them how it's in their best interest to use their power to take your land from you and give it to me. Developers do this crap all the time. They work with public housing redevelopment authorities. They work with the mayors of towns, and they get them to use their right of eminent domain to take your land and turn it over to me because I'm going to build some luxury housing there. And all the additional tax revenue that it's going to generate is going to be for the greater good of the public. So eminent domain laws get abused all the time. Take a look at this example that combines water rights and eminent domain.
Jacob.
Signs giving pleasantries.
The Almighty Himself did not convince us to live complicated. What about the federal government? You know who I spent the morning with? Your friends over at the power company. I want to know how it was that they were able to get your ancestors off the planet so quickly back in 1929. You know, Well, they got an assist from a little thing called riparian rights, Army. It's the laws that say who owns land under a body of water. Stops to consider the land under a lake, or in this case, the Missouri, which last time I checked was a federal waterway. What this means, Jacob, is that the instant you flipped your land and connected it to the Missouri, you ceded all of that flooded land to the U.S. government. Which is how I managed to obtain a written order guaranteeing our workers access to the boat. Now, if you defy this order, we can have the U.S. Marshals escort them. Odds. We don't know about domain. The feds are going to give all the surrounding land to our business partners. The roads, yes, access roads because it's in their financial interest. Tax revenue from said development is going to be massive, just like it was in 1920. Above, around, and below.
That's the moment where he realized he's been beat.
Wow.
So soon behind you, but I don't feel much like breathing. If you try to fight this, it will cost you a lot more than a bullet in the shoulder.
Oof.
Which is why you asked to meet me alone. You were afraid Darlene wouldn't be quite so receptive. You have them? So long as you keep Darlene in line. Oh, Darlene. Seeing profits are going to make you richer than and you can use them to buy twice the land.
Ooh, gripping. So this is actually that story. This is actually from a Netflix series called Ozark. This is for season 2, episode 9 of that series. If you haven't seen it, check it out. But it is it does have a lot of violence to it. It is pretty graphic.
It's such a good show, though. It's awesome.
Yeah, but it is a good show. Yeah.
All right, I have to watch it. Okay.
But look, see, now that you're in real estate and you're studying real estate and you're learning all these new terms and definitions, when you start to watch programs on TV and you hear these terms, oh, water rights, oh, eminent domain, oh, riparian rights, I know what that is, I know what that is. Or like when you start seeing signs that say certain things that deal with real estate that I teach you, you're going to be like, because you now possess knowledge greater than that of the general public has. So you're learning these things. This is why courts will hold you to a higher standard or a higher degree of care that you need to supply to your clients, because you possess greater knowledge than the average person out there in the general public now. Now, as long as you use it to your client's benefit, there's no problem with that. Okay, what's this? So let's get back to the lesson here and continue on. So frontage, I said, when we talk about frontage or front feet, we're talking about how wide the front of the lot is. When we're talking about a land that is near the water, whether it's a whether it's the ocean or a lake or a river or stream. The more valuable side of the land is the side that's touching the water. So frontage is not measured on the front of the property. The front of the property is considered the more valuable side, which is now the side that's facing the water. So waterfront property, that's why they call it waterfront, beach front, lake front. The frontage is switched to the backyard now. So here's an example. Normally facing the street, you got your house over here and the frontage is the width of the lot facing the street. If you got waterfront property, you measure the frontage based on the side of the lot that's facing the water. Anything that's inheritable is referred to as a hereditament. You don't need to study that word for exams. You're probably not going to see it on exams. Wait, I lie. You probably will see it on exam as a wrong answer option. They do use real words in their multiple choice, but they're not going to give you any question about hereditament because it's easy to figure out. It even sounds like inherit. Anything that you can inherit is a hereditament, you know, so they're not going to give you something that obvious or easy. Now, chattel, this is a term you'll absolutely get on exams. You need to. Sometimes you see it with an S, sometimes without. Sometimes it's just chattel, sometimes it's chattels. There's a very particular definition for it, and don't be lazy in defining it. It is tangible personal property. Don't just say chattel is personal property, because that's wrong. Because can you have personal property that's not tangible, that's intangible? Yes, you can, like your rights. So chattel is tangible personal property. It's personal property that you could touch. It's movable. It's not attached to the real estate. Your furniture, your clothing, that's all chattel. Your car. So let's highlight tangible personal property is referred to as chattel on page 97.
Got it.
Now, real property versus personal property. Real estate is land and anything that's permanently attached to it. Personal property are movable items that aren't attached, like vehicles. Fixtures are items that were once personal property that you could move around. You go to Home Depot, you buy a mailbox, it's your personal property. But now you dig a hole in the ground, you put a post in the ground, you attach the mailbox to it. It's now attached to the real estate. It's now part of the real estate. So a fixture is an item that was once personal property. It's been converted to being part of the real estate, and it's considered part of the real estate. Trade fixtures, on the other hand, are attached to the real estate, but they're still considered personal property because they're used to run a trade, a business. That's what a trade is. You guys are here to learn a new trade, the real estate, right? So a trade fixture are any fixtures that are used for business purposes, and they could be removed by the tenant as long as they remove it before their lease expires. If they do not, it is possible for a trade fixture to become a fixture, which is part of the real estate. So real property ownership is transferred by deed, while personal property is transferred by bill of sale. Let's highlight that on page 98. It's at the top of the page in the first paragraph there. Real property ownership is transferred by deed, personal property transferred by bill of sale.
Okay.
And once again, I have the definition here that a lease is considered to be personal property that's an intangible asset because a lease symbolizes the rights of the tenant to occupy the owner's property for a limited period of time as defined in a lease. So you cannot touch your rights. Therefore, it is intangible asset. And the renter doesn't own the real estate, therefore it's not considered real property, it's considered personal property. And there's only two kinds of property in this world. It's either real estate, real property, or personal property. So it's a personal asset that's intangible. You can't touch the rights that allow you to live in someone else's property, and you don't own the real estate, so it's personal property. So here's some more terms and definitions that you got here on this page that we're going to be highlighting as well. I'll show you what the highlights are in the next slide, but let's just go over that. You could snap a picture of these definitions I got here. Some of this stuff was on the previous pages too. A corporeal is another word for tangible. It's an asset that you could touch or feel. Incorporeal is another word for intangible asset, and it's something that's based on emotions, like your beautiful views and rights or interests in stocks or leases that you have and value. Chattel is tangible personal property that's usually movable and not attached to the real estate. A deed is the document that's used to transfer the ownership of real estate, whereas a bill of sale is used to transfer the ownership of personal property. Severance is a fancy word. You're not going to get it on exam, but severance is what we refer to as the process of transforming an article of that's considered to be part of the real estate into personal property. And one example of that is if you take a tree and you cut it down. The tree is part of the real estate because you don't have to plant it every year for it to still be there the next year. But if you cut down that tree, severing it from the earth, it becomes personal property. And now you could sell it like a Christmas tree, right? Now, emblements are annual crops that you need to plant every year, and they're considered personal property. So let's look at it from the farmer's perspective instead of from the single family house owner's perspective. A tenant farmer is allowed to return to pick the fruits of their labor to harvest the crops that they planted after they tilled the soil, planted the seeds, grew the crop. They're allowed to come back even after a farm has been sold by the owner of the land because they're a tenant there, to pick their harvests. Because that is their property. Next year, that harvest won't grow on its own. They have to till the soil, plant the seeds, care for it all over again. Otherwise, it's not going to be there. So they're allowed to pick their property, their fruits of their labor, so to speak. I had a girl in one of my classes. During this real estate class, she was closing on the purchase of her property. And she was talking about how she loved the landscaping. She was buying it from this little old lady that really took care of the property. Like she'd be out there on her hands and knees with a knife and scissors and trimming the lawn and the edges of the landscaping and stuff. And she was like, wow, this lady, the property's beautiful, the way it's well manicured, the front lawn with the flowers that she has laid out there and everything. She said she was doing her final walkthrough before the closing on the house. And when she's going there to do the final walkthrough, the old lady was out there at the front, in the front of the property with, and she was digging the flowers out of the ground and putting them in pots to take with her. She was like, oh, I just can't right now. But then again, these are flowers that you would have to plant every year. They wouldn't survive the winter anyway, so those are considered personal property. So the old lady could have taken him with her, but I mean, who really does that, So she was just kind of blown away with the fact that this little old lady was out there taking the flowers before she sold the property. That's kind of far out there, but I guess it can happen. So those are considered emblements, right? They're not going to be there next year unless you plant them again.
Mm-hmm.
Now, fixtures, once again, they're items that were once personal property. You went to Home Depot, you bought a chandelier. That chandelier is personal property. Now you take it home, you bolt it to the ceiling, you hardwire it to the electrical. Now it's part of the real estate. So if you sell that real estate, you can't take the chandelier with you when you sell the property, unless you notify the buyer in advance before you guys agreed to and got into a legally binding contract with each other that you were going to be taking the chandelier with you. Otherwise, if you didn't discuss that and then you just go and remove it, that's like you taking the toilet bowl with you. You know, it's part of the real estate. You can't do it. You're now fundamentally changing the real estate. You're taking part of the real estate that the buyer didn't agree to that. So the seller's in breach of contract if they were to do that. So I actually use this as an example a lot of times to classes where I tell people this. And I said, I mean, would you take the toilet bowl with you when you leave? You know, it's part of the real estate. And I actually had one lady in my class, she's like, she's like, I'm selling my house. I'm taking my toilet with me.
What?
Everybody said the same thing. Everybody was like, what? Everybody like shot her a look like, what the hell are you talking about? You got to take the toilet. Everybody started laughing in class. This was like one of the last in-person classes that we had before the whole COVID thing, you know, and everybody shot a look at her. And I was like, what? You're going to take the toilet bowl? She's like, listen, she's like, you know how hard it is to find a toilet? She's like, I'm a tall woman. She's like, and my husband's even taller than me. You know how hard it is to sit on you little people toilets? You know how hard it is to find a toilet that sits up that high? She's like, so I'm taking my toilet bowl with me whenever I move. I'll replace it with something else, but I'm taking my toilet. And I was like, you know what? Stop right there. You're making a good argument, actually. You're making a good argument for why you would want to take it with you. However, what if the buyer fell in love with your toilet too because they're tall and they usually don't see that in their houses? So maybe they fell in love with it too, and that's why they made an offer on your house. Unless you told them that you were going to be removing that toilet, now you're changing the real estate, and they didn't want to buy the property with a little people toilet either. You know, so you got to think of it from that point of view. You're now changing the real estate. That's like you removing the cabinets off the wall in the kitchen when selling the property. After you became under contract with somebody to buy the property, they fell in love with the gorgeous custom cabinetry, and now you're removing it. They didn't agree to that. They based their purchase price based on the beautiful kitchen that was there that you're now disassembling. So you would be in breach of contract if you were to do that. So these items are considered fixtures. You know, you go to Home Depot, you buy some cabinets, that's personal property. But once you attach them to the walls in the kitchen, they're now fixtures. They're part of the real estate. If you remove them, you're in breach of contract unless you came to an agreement beforehand that you're going to be removing them. Now, trade fixtures are considered to be personal property. They're used for business purposes. They're installed and used for business purposes by a tenant who can remove them before their lease expires. Otherwise, if they don't remove them before the lease expires, it is possible for those trade fixtures to become fixtures, which are part of the real estate, and now the property owner will own it. Some examples of trade fixtures are a barber's chair, gas station pumps, shelving in a supermarket, sinks in a beauty salon. Even though they're connected to the plumbing, they're used for business purposes, those custom sinks, you know, with the carve away for your neck to be put in so they wash your hair and stuff, you know. So that beauty salon, if they move that business out, they could take those sinks with them, or the barber's chair, you know, that may be bolted to the floor. You know, they could take that with them as long as they remove it before the lease expires. If they don't, it's part of the real estate now, and now you can't take it. So let's do the highlights now for all this stuff. Annual crops, this is page 98. Annual crops such as wheat, corn, and garden vegetables are considered emblems and are considered personal property. Yes, I said wheat, like Stewie. Now, mobile homes, unless they've been removed from their axles and permanently attached to a foundation, are also considered personal property. However, real estate brokers who are not licensed as motor vehicle dealers can legally broker the sale of mobile homes. All they got to do is make sure that they fill out the title to that vehicle, and you could transfer the ownership and earn a commission for the resale, not for new mobile homes, but for the resale of existing ones. All right, let's do the highlights here on fixtures and what a trade fixture is, and write the notes in there and down here.
Okay. Okay.
Okay.
Okay, I'm good to go.
Good to go.
Yep.
All right. So once again, fixture is an item that was once considered personal property that has now been attached to the real estate. It's become part of the real estate, and trade fixtures are personal property that's used, or fixtures that are considered personal property that can be removed by the tenant before the lease expires. Now, there are legal tests to determine whether something is considered part of the real estate, which is personal property, or if it's a fixture, which is part of the real estate. But these rules are not that clear. Look, the intention of the parties who installed the items, the method of annexation, the adaptation of the article of the real estate, and the relationship of the parties. These are the legal tests. But, not all these things can be interpreted in the same way. So keep in mind, not all judges rule uniformly. That means the same on matters. So it's not always clear as to what's considered personal property or real property. Let me ask you a question. If you have a throw carpet in your living room, it's like a 5x10 carpet. Is that personal property or part of the real estate?
Personal.
Okay, so you can roll it up and take it with you when you leave.
Yes.
What about wall-to-wall carpeting that's cut out to fit the edges of the room and
No.
stapled down at the edges?
That
Real. Real.
Personal or
Real.
part of the real estate? I agree.
Yeah.
But there are instances where judges agreed with people that it's personal property and they could take it with them.
Wow.
Yeah, but don't they have to put something else down, though? Is it contingent upon that?
It's personal property. They could take it with them. So that's the thing. Not all judges rule the same. I mean, so far, all of us consider it to be part of the real estate. If it's like cut out to fit that particular room size, it's stapled at the edges, that's part of the real estate. The floor underneath it's probably going to be all banged up, right? So
Right, I'm sorry.
Yeah, so we consider it to be a part of the real estate, but not all judges rule the same. So because of that, there's no uniformity in it. So always ask the owners when we get a listing, what's going with the real estate and what are you taking with you, so that we don't run into these issues that could become blown up into arguments and lawsuits later on. What is going with the real estate and what are you taking with you?
Mm-hmm.
We should always do walkthroughs. Do walkthrough inspections plenty of times when selling a house. When we first go to get the listing, when buyers go walking through homes to see if it's something that they're interested in, when we get home inspections or appraisals done. We do follow-up walkthroughs after initial home inspection. If we find that there's problems, the seller says that they're going to fix them. Now we got to do a follow-up inspection to make sure that they did the work and they fixed it properly. We get our municipal inspections, fire inspections, and certificate of occupancy inspections are required before we could close. We also have the final walkthroughs, which should be done the day of closing. Now, me, like most other agents out there, once the seller moves all their crap out of the house, that's when we do the final walkthrough, which could be a week before the closing, you know. But I'm going to tell you, always do it the day of the closing, because I'm going to share with you one of my experiences that I had that wasn't so pleasant. I never dealt with this before, but one day I did. First of all, why do we do final walkthroughs before the closing? Well, we want to make sure that the seller moved all their crap out and they didn't leave like broken furniture or piles of garbage behind. Otherwise, they need to remove that stuff. You know, we need to deduct probably from their proceeds the cost of getting that crap taken out if they don't want to do it. You know, we got to negotiate on that because they're supposed to sell the property and leave it in broom clean condition. What is broom clean condition? Doesn't mean they need to scrub the house down. It just means that they're not leaving piles of garbage around. Okay. And that when they move their stuff out, they didn't put holes in the walls or gouge the floors or remove any part of the real estate that they shouldn't have, like the toilet and, you know, things like that. Now, I had an instance one time where I had some buyers that were purchasing a pretty high-end property, but it was a short sale. The seller's trying to avoid a foreclosure. So they're selling the house. Now, with short sales, typically you can't walk away with a penny of profit. So I'm helping this person by bringing my buyers in and purchasing this house, helping him avoid the foreclosure. So we do the final walkthrough the evening before the closing, not the day of, not a week before, but the evening before the closing. And so we do the final walkthrough of the house. It's got one of these beautiful, gorgeous high-end kitchens with Viking appliances and custom cherry wood cabinets in the kitchen. It's beautiful. Now, the next morning, the day of the closing, I'm about to go there, go to the closing. You know, everything was fine with the final walkthrough the evening before. The next morning, the listing agent calls me and asks if I could do her a solid. If she gave me the code to remove the shackle for the lockbox, and I could bring the lockbox to the closing table because it's out of her way to get to the property, but it was on my way. So if I could stop by the property and do her a solid and pick up the lockbox for her, if she gave me the shackle code, and I was like, yeah, sure, I could do that for you. Now, when I did that, I had to run to the bathroom. I had to pee real quick. So I ran in the house, you know, and while I was in the house, I just ran through it and did a quick walkthrough again really quick. And then I went to the closing. I locked it up. I went to the closing. Now, I go to the closing and the attorney's asking the buyers if everything was all right. They get a chance to do a final walkthrough. And they're like, yeah, everything was good. And that's when I'm walking in. And I was like, I heard this. And I was like, we got a problem. And they're looking at me. I was like, yeah, I know we just did the final walkthrough yesterday evening. But the gorgeous, beautiful, high-end kitchen that was there with Viking appliances and cherry cabinets and granite countertops and all, it's all gone.
Oh, God.
They took the cabinets off the wall. They literally took the kitchen sink. All there were pipes sticking out of the wall and out of the floor. And I was like, are you for real? This guy took these Viking appliances, which are very expensive, by the way. And granite countertops. He had to have a whole crew of people. You know how heavy granite is? You know, yeah, he must have had a whole crew of people and a big truck taking all this stuff out overnight. And so he stripped out the kitchen. Now, if I didn't catch that, the buyers are going to purchase a house. They're going to go to their house, their new home, so excited to find out that they've been robbed. Call the cops. You've been robbed. You got to file an insurance claim. Somebody just stripped your kitchen. You know, but luckily I caught it. And I was pissed. Real estate agents are supposed to keep the emotions out of it, but I was pissed. And this guy had the balls to come to closing. So I'm like getting in his face about it. I'm like, listen, you lived in this house for the last 4 years without making a mortgage payment, doing these short sale things. They come across before you're about to get foreclosed on, and they saved your ass. You are gainfully working, not making mortgage payments. And now you're going to try to screw them over by when they're purchasing the house to save you from a foreclosure, and you're going to go rob them and steal the house. I was getting into his face, and I, said a couple expletive deletives, I'm not going to get into it here. But anyway, I told him, I was like, this is what's going to go down now. They're either going to back out of this transaction right now, sue the hell out of you, and your mortgage and your lender is going to foreclose on you, or you're going to come to closing. We're going to do a dry closing right now. You're going to go and bring back all of those appliances. You could keep the countertops and stuff, because who knows if you're going to crack them on the way back. Granted, it can be very tricky that way. So you're just going to come back with all them Viking appliances, and we're going to inspect them, make sure that they're not dented or dinged up and that they still work. And then you're going to bring a check, and you're going to give them money. You're going to give them cash. Forget about check. You're going to bring them cash. You're going to give them money so that they could buy new cabinets and countertops and sink and have it installed. I'll leave it up to the attorney to negotiate with you how much that's going to be. But if you don't do that, they're not going through with this closing, and they're going to sue the hell out of you, and you're going to get foreclosed on. I was like, that was a scumbag move that you did, and then I backed off and I let the attorney handle it from there. But good thing I caught it. Good thing I caught it.
That's criminal. That's criminal to me.
Yeah. I mean, imagine your clients are so happy that they pulled on the house. If I didn't go into that house, they would have been mad at me.
Yeah.
How did you not prevent this from happening? We did the final walkthrough just last night. You were there with me. Who would have thought that they could rob it like that?
Yeah.
But thank God I caught it. I mean, my clients were like, really? What just happened? They're like, they're glad that I did what I did there for them. But I wouldn't have known if I just did the walkthrough the evening before and didn't do it that day of. So that never happened to me before. That was one instance that ever happened like that. I mean, prior, I did have another instance where nothing like that happened, but the person left a garage full of garbage. So what I would suggest that you do is the final walkthrough on the day of the closing. Because in case something like this happens, so live through my mistakes. Okay. Learn through my mistakes. Okay. So I'm trying to teach you some life lessons here to be better agents so you don't have to deal with this crap that I've dealt with.
Yeah.
Okay. So once again, title. This is not a new slide for you. Remember, I showed you guys this slide before. The word title means ownership. And there's no document in real estate called title, right? How do we transfer personal property? By bill of sale. How do we transfer real estate? By deed. A deed is the document we use to transfer title. But a deed is not proof of ownership. It's not proof of title. So what is? Abstract of title with attorney's opinion, certificate of title, a title insurance policy, and a Torrens certificate, even though we don't use them in New Jersey. And which is the most common form of proof of ownership that's used in New Jersey? The title insurance policy.
Yeah.
And when does the transfer of ownership take place? Upon the delivery and acceptance of the deed itself.
Right.
All right, that concludes chapter 5. So let's do the key terms to review for chapter 5. There are 2 key terms to review for chapter 5, so let's get into it, shall we? The wearing away of land, usually due to the actions of the wind or water.
Oh God, what page is that?
That's page 100.
Okay.
What do we call that? The wearing away of land by wind or water.
That. Ooh. Ooh.
What do we call the wearing away of metal When it rusts.
Erosion.
Erosion, right?
It's the same thing. There we go. Erosion. It's eroding away. 10 is A.
Okay.
Anything that can be inherited is a. Even sounds the same.
What number we, oh, okay, B. Anything that can
What do we call anything that can be inherited?
Rediment.
It's a herediment.
Yep.
12 is B. Once personal property, now real estate.
fixture?
It's a fixture. 11 is C. Rights of a landowner to use waters adjoining streams or waterways not affected by tidal currents.
Riparian right?
13 is D, riparian rights.
Okay.
A sudden change of the course of a stream.
Oh, accretion? Avulsion or wait.
Avulsion. Avulsion. Avulsion has the S in it for sudden change of a course of a stream. 4 is E. Tangible personal property is also known as
Chattels.
chattel. Chattel or chattels. 6 is F. Solid material deposited by a body of water. What do you call the solid material? The dirt, the sand, the soil, the rock that's deposited by the water.
Accretion? Or no, avulsion?
No, we already did. Avulsion is a sudden change of a course of a stream.
Oh, okay, I'm sorry. I'm looking at the other one. Okay.
Accretion?
No,
Right?
no. Accretion is the process of the water depositing the solid material. But what do we actually call the solid material that is deposited by the water through the process of accretion?
Divine?
You gain an L, you gain some dirt.
Oh, God.
The one with two L's, alluvian.
Oh.
Alluvian. 3 is G.
Wait,
And-
So,
Go ahead.
go ahead.
number 4 was E, right?
Number
Right.
4 was E, correct. Avulsion.
And then 3 is G. Okay.
Tangible personal property. Oh, wait, we already did this. Tangible personal property. 6 is F. Chattels. We already did solid material deposited by a body of water. That is alluvian. 3 is G. Okay, now we're on H. An increase of land caused by the gradual depositing of solid material by the actions of the water. What do we call the actions of the water depositing that solid material called alluvian?
Accretion?
Accretion. 1 is H. Another word for tangible.
Oh,
Feel.
Corporeal.
Yeah.
7 is I. 7 is I. Corporeal.
Real.
It's not corporeal. There's an extra O in there. Corporeal. Corporeal. 7 is I.
okay.
Rights of a landowner to use bodies of water affected by tidal currents.
Implement?
Sorry?
Oh, littorical right?
Littoral rights.
I mean,
5 is
littoral.
J. Yep, littoral rights. 5 is J. Belonging to the land, belonging to the owner of the land below. Let's just stop and evaluate that for a second. If the land is below, what's above?
Air rights.
2 is K. There you go. That's how we came up with that answer. Annual crops are also referred to as
Implement?
emblements. 9 is L. To leave real estate to someone by will.
Devise.
Devise. 8 is M. Okay. Key terms 2. The earth, including the air above. If the air is above, what is below?
Riparian, right? No.
Subsurface.
The earth, including the air above.
Wait a minute.
If the air is above, what's below?
Subsurface rights.
What's below the air?
Not riparian.
Real estate.
What's below the air? If the air is above, what is below the air?
Minerals?
Land.
Oh.
The land. 2 is A.
Wait.
I think this is the most difficult chapter for me.
I know. I'm like,
It's just a stupid way that they word it.
yeah.
Land. I'm trying to guide you through it a little bit.
You are. I see the hands up, down.
If the air is above, what's below the air? The land. You're walking on it, right? Land improvements and bundle of rights. Land improvements and bundle of rights. What is that the definition of?
Wait. Where are we? Land improvements.
The land improvements and the bundle of rights.
Real property.
Real estate.
Real estate.
7 is B. Removable by the tenants in commercial property anyway.
Trade fixtures.
12 is C, trade fixtures. Subsurface rights are also referred to as
subsurface rights.
they're also but what do we also refer to subsurface rights as?
Mineral rights.
Mineral rights. 4 is D.
Okay.
Land bordering bodies of water that are affected by the tides.
Oh, I just saw that.
Reliction.
There you go.
No.
Oh boy.
Riparian?
What form of ownership of land is bordering waters affected by the tides that are navigable? You got high tide and low tide.
Littoral rights.
Littoral rights.
Littoral, okay.
Correct.
That's tired. Don't mind me.
Okay.
No. Wait, what was that again? Number 3.
3 is E as in
Okay. Okay.
Use of water by adjoining landowner.
Repairing.
So say you have 2 property owners and they both share the water use in between them. What kind of property rights do they got? Use of water by adjoining landowners.
Riparian, right?
10 is F, riparian rights. Remember, the center of the stream becomes the property line. So 10 is F. Okay, now it's a real estate class. A synonym for real estate is?
Real property realty?
Yeah, it's real property realty. 8 is G. Creation of dry land by the gradual withdrawal of water from it.
Wait, what?
Creation of dry land. The land was always there. It's now just dry because the water withdrew from the land. What did you say, Kelly? Yes, reliction. 9 is H. Everything that is real property is considered to be, there's only 2 kinds of property in the world. So if it's not real property, what is it?
Personal.
There you go. 6 is I, personal property. Another word for intangible.
Incorporeal.
Incorporeal, one is J. Ownership of the minerals, oil, and so on.
Land.
Subsurface
Oh,
rights.
Subsurface rights, 11 is K. And I expanded on the definition of L here, where it says a specific tract of land. I wrote right after that, with legally defined boundaries. A specific tract of land with legally defined boundaries.
Okay.
Parcel.
It's a parcel. 5 is L.
Okay.
Okay. And that concludes chapter 5.